everybody. Sorry, I'm turning my mic down because all the people with these comments yesterday, they're like, your fucking mic is so loud. I hate you. It's so crazy. I hope you guys are having a wonderful morning so far. We are in the process of verdict watch. This is one of the biggest days. Let me turn it up a little bit and ignore the haters. Um, we are in one of the most important days of this trial, right? So, right now, we have gone through closing arguments yesterday. And today, we are going to have the judge read jury instructions, and the jury is finally going to go into the deliberation room and get started. What that means is we could get a verdict back today. We could get a verdict tomorrow, but I don't think we're going to go into Mother's Day. Happy Mother's Day weekend to all of the moms that are out there, whether you're a mom, a grandmom, a dog mom, whatever type of mom. I hope you guys enjoy Mother's Day weekend. I have cleared my entire schedule so we can focus on this. All right, we've got our coffee. Let us go to the courtroom and see what's happening. Listen to the jury instructions. I'll give you guys some predictions on what I think is going to happen with verdict watch today, and we'll talk about the game plan from there. Also, if you are taking the time out of your day to leave me a comment to tell me that my soundboard is loud, find something else to do. You know what I mean? Like, just find something else to do. We know the courtroom volume's low. Mine is loud. Compared to the two, it's not a good balance. It's so annoying, but it's okay. We laugh it off over here. Okay, let us go to the courtroom and see what's going on. Let me put my audio booster on to the max and go from there. Looks like everybody is in the courtroom for this final day. Davion has switched places.
Present, defendants are present, defense counsel's present. So before we get going, we do need to bring in Juror 32 and initials CRP. So if you please bring that juror in.
Your Honor, briefly.
Yeah, okay.
In talking to Mr. Wise, who's not here, there he is, at the very moment, Judge, and in our conversation yesterday about alternates, was the court considering, I just wanted to clarify, that in excusing one of the alternates and keeping two.
Wait 1 second. Yes.
In excusing one of the alternates and keeping two, that we would intend to potentially excuse the one that had the exchange with Mr.
Well, that was his motion. So, but I'm going to talk to the juror first, and then you can see if you renew the motion or not. Okay? That was the request from Mr. Wise. Okay, I'm sorry, just bring him in. Good morning, sir. Just have a seat. You're good. You're good. Just have a seat. Yeah, have a seat. Everyone have a seat as well. So it was brought to my attention that you may have had some interaction with one of the prosecutors in this case. Do you remember saying like good morning or good job or anything along those lines? Okay.
Yesterday, Your Honor.
Okay. Okay. And what did you say specifically?
Good job, I think so.
Okay. And I know we had a discussion about the fact that the attorneys could not have any contact with you, and I may have not been clear that also includes you all not having any contact with the attorneys. So let me just ask you this question. Is there anything about that you think would impair or impact your ability to be a fair and impartial juror?
No, Your Honor.
Okay. And do you understand that the defendants, all four of the defendants, are presumed innocent unless and until the state proves their guilt beyond and to the exclusion of every reasonable doubt?
Yes.
And can you give the defendants the presumption of innocence and hold the state to that verdict?
Yes.
Okay. Any questions from the state?
No, Your Honor.
Okay. Any questions from any counsel?
No, Your Honor.
There you are.
Mr. Gonzalez
There you are.
and Mr. Petrides. Okay. Thank you so much. You can join the others.
I'm sorry.
It's okay. It's okay. It's all new for everybody. Well, some of us. Okay. Any additional motions?
So if you guys are watching with me live, yesterday we did see the little kerfuffle or the little spat between Davion and Rashad. I could not hear exactly what Davion was saying, but they had to remove him from the courtroom. And we just heard Rashad saying, "I'm going to pray for you, bruh. I'm going to pray for you, bruh." Do you guys know exactly what Davion said? Because right now, even just with the courtroom dynamic, notice that Davion and Sean, their placements have changed. So Davion is sitting at Sean's table. So we're going to see what's happening. I am also putting up a new poll. The poll is how long for the verdict? Here are your answer choices. Option 1 is today in the afternoon. Option 2 is today in the evening. Option 3 is tomorrow morning. Option 4 is tomorrow afternoon. So I'm going to put that in the chat. Y'all have an opportunity to vote it up. But yeah, so Davion and Rashad had a little spat yesterday, and they are cousins, but I did kind of pick up on it. I heard them moving him and he was saying something, and then Rashad kept saying, "I'm going to pray for you, bro. I'm going to pray for you, bro." So I don't know what happened. But I did chop up our live from yesterday and give you guys chapters. I haven't done that in a few days, but the chapters are up there. And some of y'all are saying that Cam from Cuff Boys did a video on it, and a few other people have done that. So, shout out to Mama Foolio on Mother's Day weekend. I hope she gets the guilty verdicts back. That would be an amazing Mother's Day gift for her. I did see that she went live yesterday, but of course, people are reporting her lives like, leave her alone. Like, she's already going through a lot. You know what I mean? Like, people are so crazy. Anyway, the poll is up in the chat. There was discussion yesterday evening about a juror who spoke to a prosecutor. Judge Sisko just talked to that juror to see if they would still be fair and impartial. But the question to that juror was, "Hey, what did you say to the prosecutor?" And apparently the juror just said, "Hey, great job." That's it. So, they were trying to get the juror removed for a minute, but it looks like, we're moving on from there. All right, you guys are saying Kat, not Williams, had posted it too. Of course, Kat live streams just like me, so I'm pretty sure she heard it and seen it, but I just wanted to make sure we went from there. All right, y'all, big day. The poll is up. It looks like right now you guys are saying that the verdict's going to come out today. Popular choices today, not tomorrow. Okay, let's go back into the courtroom. We are going to hear the jury instructions and go from there.
We would not be making a motion this time.
Okay, very
Yes,
good.
we would agree.
Okay. So, I know we discussed the state expressed some hesitancy in not bringing all 3 alternates back if necessary. We're talking about a week. So is still your position that all 3 would need to come back next week?
Judge, it is. I mean, I am concerned, not through any fault of any jurors in the past, but there have been situations that have arisen where we have had to use every single alternate that we have, and just because of the length of this trial and everything that we put into it.
Okay, I understand. All right. I'm glad I'm on record saying I would excuse at least one. So there you go. Okay, and then after I instruct the jury and after they begin their deliberations, I'm going to rule on the Davion Murphy's motion for mistrial. Okay. Anything else that we need to discuss before I bring in the jurors? Okay, hearing nothing, let's go ahead and bring them in.
All rise.
So the jury is coming in, and like I mentioned yesterday, guys, let me turn my mic down. As you can see, Sean has now switched spots with Davion because of whatever happened yesterday.
All jurors right there.
Okay, very good. All right, and we need to pass out a copy of the jury instructions. Oh, they already have them? Okay, very good. So I'm getting ready to give you your final instructions on the law. I've given each of you a copy of those instructions so you can read along as I'm reading them to you, okay? All right, let's begin. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Isaiah Chance, Sean Gathright, Rashad Murphy, and Davion Murphy, the defendants in this case, have been accused of the crimes of murder in the first degree and conspiracy to commit murder in the first degree. Defendants Sean Gathright, Rashad Murphy, and Davion Murphy have also been accused of 3 counts of the crime of attempted murder in the first degree. Defendant Sean Gathright has also been accused of the crime of tampering with physical evidence. In considering the evidence, you should consider the possibility that although the evidence may not convince you that a defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute lesser included crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if a defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder are second-degree murder and manslaughter. There are no lesser crimes indicated in the definition of conspiracy to commit first-degree murder. The lesser crimes indicated in the definition of attempted first-degree murder are attempted second-degree murder, attempted manslaughter, and aggravated battery. There are no lesser crimes indicated in the definition of tampering with physical evidence. Introduction to homicide. Isaiah Chance, Sean Gathright, Rashad Murphy, and Davion Murphy are accused of murder in the first degree and conspiracy to commit murder in the first degree in counts 1 and 2. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, all of which are unlawful. However, a killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Charles Jones was killed by Isaiah Chance, Sean Gathright, Rashad Murphy, or Davion Murphy, you will then consider the circumstances surrounding the killing and deciding if the killing was murder in the first degree, murder in the second degree, or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I will now instruct you on the circumstances that must be proved before a defendant may be found guilty of murder in the first degree or any lesser included crime. To prove the crime of first degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Charles Jones is dead. 2, the death was caused by the criminal act of the defendant. 3, there was a premeditated killing of Charles Jones. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Murder in the second degree, lesser included offense of count 1. To prove the crime of second degree murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Charles Jones is dead. 2, the death was caused by the criminal act of the defendant. 3, there was an unlawful killing of the victim by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Manslaughter, intentional act or culpable negligence, lesser included offense of count 1. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Charles Jones is dead. 2A, the defendant intentionally committed an act or acts that caused the death of the victim, or B, the death of the victim was caused by the culpable negligence of the defendant. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. Each of us has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care toward others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. Principal instruction as to count 1 applies only to count 1. If a defendant helped another person or persons commit a crime, that defendant is a principal and must be treated as if he had done all the things the other
Sorry. I was over here like excited about this super chat. Huge shout out to Christopher Williams. I was saying that I just had a dream about Jay-Z last night. It's so odd. But thank you so much, Christopher Williams. If y'all could do me a favor, he is your stream sponsor. We're watching jury instructions right now, and we're at a very important part. Remember, we were talking about culpable negligence? That applies to Rashad. The principal theory is applying to all of them. But if y'all could do me a huge favor and shout out Christopher Williams, he's one of my longest running supporters. Sponsored so many different trials on this channel. We would not be willing to, we're not going to be able to do this without sponsors like Christopher Williams. Y'all know how hard it is to run a YouTube channel and for me to run my team and everything else that's happening. So when people are generous like this, it really means a lot. I usually don't stop the show, but when somebody steps out the frame like this, I definitely have to acknowledge CW. But thank you so much, Christopher Williams. Let's go back into these jury instructions. Remember, there is a poll up right now. There's also a motion for mistrial from Davion that the judge is going to talk about in just a minute. But let's go back in.
Person or persons did if the state proved beyond a reasonable doubt. Number one, the defendant intended the crime to occur. And two, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. To be a principal, the defendant does not have to be present when the crime is committed. For first-degree premeditated murder, the state must prove the defendant intended that the killing of Charles Jones occur. For second-degree murder, it is not necessary for the state to prove the defendant intended the death of Charles Jones. It is not necessary for a principal to know every detail of how a first-degree murder, second-degree murder, or manslaughter will be committed, as long as the principal intended the first-degree murder, second-degree murder, or manslaughter to occur, and did some act or said something that was intended to help and did help the first-degree murder, second-degree murder, or manslaughter to occur. To be found guilty of first-degree murder with a firearm, second-degree murder with a firearm, or manslaughter with a weapon as a principal, it is not necessary for the state to prove a defendant knew another participant of the first-degree murder, second-degree murder, or manslaughter would be or was armed. Criminal conspiracy count 2. To prove the crime of criminal conspiracy, the state must prove the following two elements beyond a reasonable doubt. Number one, the intent of the defendant was that the offense of first-degree murder would be committed. And two, in order to carry out the intent, the defendant agreed, conspired, combined, or confederated with one or more of his co-defendants to cause the first-degree murder to be committed either by them or one of them or by some other person. It is not necessary that the agreement, conspiracy, combination, or confederation to commit first-degree murder be expressed in any particular words or that words pass between the conspirators. It is not necessary that the defendant do any act in furtherance of the offense conspired. Introduction to attempted homicide applies to defendants Sean Gathright, Rashad Murphy, and Davion Murphy. The victim in count 3 is Xavier Edwards. The victim in count 4 is Gino Norris. The victim in count 5 is Camilla Bentley. Sean Gathright, Rashad Murphy, and Davion Murphy are accused of attempted first-degree murder in counts 3, 4, and 5. Attempted first-degree murder includes the lesser crimes of attempted second-degree murder and attempted manslaughter, all of which are forms of attempted homicide and all of which are unlawful. However, an attempted homicide that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find that there was an attempted homicide of a victim by a defendant, you will then consider the circumstances surrounding the attempted homicide in deciding whether it was attempted first-degree murder or attempted second-degree murder or attempted manslaughter, or whether the attempted homicide was excusable or resulted from the justifiable use of deadly force. Justifiable attempted homicide. The use of deadly force to attempt to kill a human being is justifiable and therefore lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in or upon any dwelling house in which the defendant was at the time of the attempted killing. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means harm that is more than slight, trivial, minor, or moderate. Excusable attempted homicide. An attempted homicide is excusable and therefore lawful under any one of the three following circumstances. 1, when the attempted homicide is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the attempted homicide occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the attempted homicide is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the attempted killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. Attempted first-degree premeditated murder applies to defendants Sean Gathright, Rashad Murphy, and Davion Murphy. To prove the crime of attempted first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. Number 1, the defendant intended to commit the crime of first-degree premeditated murder. 2, the defendant committed an overt act toward the commission of first-degree premeditated murder that went beyond mere preparation. 3, the defendant failed to complete the first-degree premeditated murder. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. To prove that a first-degree premeditated murder had taken place, the state would have to prove the following three elements beyond a reasonable doubt. Number 1, the victim is dead. 2, the death was caused by the criminal act of the defendant. 3, there was a premeditated killing of the victim. A premeditated killing is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Attempted second-degree murder, lesser included offense in counts 3, 4, and 5. To prove the crime of attempted second-degree murder, the state must prove the following three elements beyond a reasonable doubt. Number 1, the defendant intentionally committed an overt act that could have resulted in the death of the victim, but did not result in the victim's death. 2, the act was imminently dangerous to another and demonstrated a depraved mind without regard for human life. And 3, the overt act went beyond mere preparation. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. To convict the defendants of attempted second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Attempted manslaughter by act, lesser included offense of counts 3, 4, and 5. To prove the crime of attempted manslaughter by act, the state must prove the following two elements beyond a reasonable doubt. Number one, the defendant intentionally committed an overt act that could have resulted in the death of the victim, but did not result in the victim's death. And two, the overt act went beyond mere preparation. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. However, the defendant cannot be guilty of attempted manslaughter by act by committing a merely negligent act. Every person has a duty to act reasonably and use ordinary care towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligent. To convict of attempted manslaughter by act, it is not necessary for the state to prove the defendant had an intent to cause death. Only an intent to commit an act that could have caused death and was not justifiable or excusable attempted homicide, as I have previously instructed you. Aggravated battery, lesser included offense of counts 3, 4, and 5. To prove the crime of aggravated battery, the state must prove the following two elements beyond a reasonable doubt. The first element is a definition of battery. 1. The defendant A actually and intentionally touched or struck the victim against his or her will, or B intentionally caused bodily harm to the victim. 2. The defendant in committing the battery A intentionally or knowingly caused great bodily harm, permanent disability, or permanent disfigurement to the victim, or B used a deadly weapon. A deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a deadly weapon if it was used or threatened to be used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. An intentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. A battery may be found as a result of the intentional touching or intentional striking of something other than the actual body of the person. However, the object that is touched or struck must have such an intimate connection with the person that it is to be regarded as a part or as an extension of the person. Principal instruction as to counts 3, 4, and 5. If the defendant helped another person or persons commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt. Number 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. To be a principal, the defendant does not have to be present when the crime is committed. For attempted first-degree premeditated murder, the state must prove the defendant intended that the killing of the victim occur. For attempted second-degree murder, it is not necessary for the state to prove the defendant intended to cause the death of the victim. It is not necessary for a principal to know every detail of how an attempted first-degree murder, attempted second-degree murder, attempted manslaughter, or aggravated battery will be committed as long as the principal intended the attempted first-degree murder, attempted second-degree murder, attempted manslaughter, or aggravated battery to occur and did some act or said something that was intended to help and did help the attempted first-degree murder, attempted second-degree murder, attempted manslaughter, or aggravated battery to occur. To be found guilty of attempted first-degree murder with a firearm, attempted second-degree murder with a firearm, attempted manslaughter with a weapon, or aggravated battery as a principal, it is not necessary for the state to prove a defendant knew another participant of the attempted first-degree murder, attempted second-degree murder, attempted manslaughter, or aggravated battery would be or was armed. Tampering with physical evidence, count 6, applies to defendant Sean Gathright only. To prove the crime of tampering with physical evidence, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Sean Gathright knew that a criminal trial, proceeding, or investigation by a duly constituted prosecuting authority, law enforcement agency, grand jury, or legislative committee of Florida was pending or was about to be instituted. And 2, Sean Gathright altered, destroyed, concealed, or removed any item with the purpose to impair its availability in such proceeding or investigation. Carrying, displaying, using, threatening to use, or attempting to use a firearm or weapon applies to Sean Gathright, Rashad Murphy, and Davion Murphy. If you find that defendant Sean Gathright, Rashad Murphy, or Davion Murphy committed first-degree premeditated murder, second-degree murder, manslaughter, attempted first-degree murder, attempted second-degree murder, attempted manslaughter by overt act, or aggravated battery, you will then be asked to determine whether the state has proven beyond a reasonable doubt that during the commission of the crime, that defendant personally carried, displayed, used, threatened to use, or attempted to use a firearm or weapon. If you find that defendant Sean Gathright, Rashad Murphy, or Davion Murphy committed first-degree premeditated murder, second-degree murder, manslaughter, attempted first-degree murder, attempted second-degree murder, attempted manslaughter by overt act, or aggravated battery, but you are not convinced beyond a reasonable doubt that the defendant personally carried, displayed, used, threatened to use, or attempted to use a firearm or weapon, then you should find him guilty only of the first-degree premeditated murder, second-degree murder, manslaughter, attempted first-degree murder, attempted second-degree murder, or aggravated battery. Actual possession and discharge of a firearm. And that, I'm sorry, I left out attempted manslaughter. So let me read that again. Just to make sure it's clear. If you find that defendant Sean Gathright, Rashad Murphy, or Davion Murphy committed first-degree premeditated murder, second-degree murder, manslaughter, attempted first-degree murder, attempted second-degree murder, attempted manslaughter by overt act, or aggravated battery, but you are not convinced beyond a reasonable doubt that the defendant personally carried, displayed, used, or threatened to use, or attempted to use a firearm or weapon, then you should find him guilty only of first-degree premeditated murder, second-degree murder, manslaughter, attempted first-degree murder, attempted second-degree murder, attempted manslaughter by overt act, or aggravated battery. Actual possession and discharge of a firearm applies to Sean Gathright, Rashad Murphy, and Davion Murphy. If you find that the defendant Sean Gathright, Rashad Murphy, or Davion Murphy committed first-degree premeditated murder, second-degree murder, attempted first-degree murder, attempted second-degree murder, or aggravated battery, you will also be asked to determine whether the state proved beyond a reasonable doubt that during the course of committing that offense, that defendant actually possessed a firearm and discharged a firearm. To actually possess a firearm means that the defendant carried a firearm on his person or had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. Definitions that apply to 3.3a and 3.3d. A firearm is defined as any weapon which is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. A weapon is defined as one, any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or two, any other object that was used or threatened to be used or attempted to be used or intended to be.
Okay, guys, I know that this is a lot. She's reading jury instructions. She has to go through all the options of the crimes that the jury can convict them of. So she's talking about murder in the first degree, murder in the second degree, manslaughter, justifiable homicide. She has to give them all of these definitions. So it is a little cumbersome. We do have to sit through it. Doesn't take that long, but I will give you guys a breakdown momentarily. But she has to go through all of this so they know what the law is. This is the law according to the state of Florida. She hasn't gotten to the death penalty side yet, but that is coming as well. Just giving y'all a brief update. Let's go back in.
Be used to inflict bodily harm. Criminal gang definitions applies only to defendants Isaiah Chance, Rashad Murphy, and Davion Murphy. If you find that defendant Isaiah Chance, Rashad Murphy, or Davion Murphy committed first-degree premeditated murder, second-degree murder, manslaughter, conspiracy to commit first-degree premeditated murder, attempted first-degree murder, attempted second-degree murder, or attempted manslaughter by overt act, you will then be asked to determine whether the state has proven beyond a reasonable doubt whether the defendant was a member or an associate of a criminal gang during the commission of the offense, and whether the defendant committed the crime for the purpose of benefiting, promoting, or furthering the interests of the criminal gang. Criminal gang means a formal or informal ongoing organization, association, or group that has as one of its primary activities the commission of criminal or delinquent acts, and that consists of three or more persons who have a common name or common identifying signs, colors, or symbols, including but not limited to terrorist organizations and hate groups. Criminal gang member is a person who meets two or more of the following criteria. 1, admits to criminal gang membership. 2, is identified as a criminal gang member by a parent or guardian. 3, is identified as a criminal gang member by a documented, reliable informant. 4, adopts the style of dress of a criminal gang. 5, adopts the use of a hand sign identified as used by a criminal gang. 6, has a tattoo identified as used by a criminal gang. 7, associates with one or more known criminal gang members. 8, is identified as a criminal gang member by an informant of previously untested reliability, and such identification is corroborated by independent information. 9, is identified as a criminal gang member by physical evidence. 10, has been observed in the company of one or more known criminal gang members 4 or more times. Observation in a custodial setting requires a willful association. It is the intent of the legislature to allow this criterion to be used to identify gang members who recruit and organize in jails, prisons, and other detention settings. 11, has authorized any communication indicating responsibility for the commission of any crime by the criminal gang. Criminal gang associate means a person who admits to criminal gang association or meets any single defining criterion for criminal gang membership. The defendants have entered a plea of not guilty. This means you must presume or believe the defendants are innocent. The presumption stays with each defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome a defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendants are not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of a defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? 8, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? 9, has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for the lawyers to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to the lawyers about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendants. It is not necessary for a defendant to disprove anything, nor is a defendant required to prove his innocence. It is up to the state to prove a defendant's guilt by evidence. The defendants each exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by this decision. No juror should ever be concerned that a defendant did or did not take the witness stand to give testimony in the case. Eyewitness identification. You have heard testimony of eyewitness identification. In deciding how much weight to give to this testimony, you may consider the various factors mentioned in these instructions concerning credibility of witnesses. In addition to those factors, in evaluating eyewitness identification testimony, you may also consider 1, the capacity and opportunity of the eyewitness to observe the offender based upon the length of time for observation, and the conditions at the time of observation, including lighting and distance. 2, whether the identification was the product of the eyewitness's own recollection or was the result of influence or suggestiveness. 3, the circumstances under which the defendant was presented to the eyewitness for identification. 4, any inconsistent identifications made by the eyewitness. 5, any instance in which the eyewitness did not make an identification when given the opportunity to do so. 6, the witness's familiarity with the subject identified. 7, lapses of time between the event and the identification. 8, whether the eyewitness and the offender are of different races or ethnic groups and whether this may have affected the accuracy of the identification. 9, the totality of the circumstances surrounding the eyewitness's identification. You have heard testimony concerning a photo lineup conducted by a law enforcement agency. Florida law requires that the person conducting the photo lineup must not have participated in the investigation of the crime alleged and must not have been aware of which person in the photo lineup was the suspect. Also, before conducting a photo lineup, the eyewitness must be instructed that 1, the perpetrator might or might not be in the photo lineup. 2, the person conducting the photo lineup does not know the suspect's identity. 3, the eyewitness should not feel compelled to make an identification. 4, it is as important to exclude innocent persons as it is to identify the perpetrator. And 5, the investigation will continue with or without an identification. The eyewitness must acknowledge in writing that he or she received a copy of the photo lineup instructions. If the eyewitness refused to sign a document acknowledging receipt of the instructions, the person conducting the photo lineup must document the refusal of the eyewitness to sign a document acknowledging receipt of the instructions, and the person conducting the photo lineup must sign the acknowledgement document himself or herself. You may consider compliance or non-compliance with these requirements to determine the reliability of an eyewitness identification made during a photo lineup procedure. Defendant's statements. A statement claimed to have been made by a defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that a defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to 1, whether when the defendant made the statement he had been threatened in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude a defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Rules for deliberation. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. Number 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendants have been proven guilty or not in accord with the law. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find a defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows.
All right, this is
State
big.
of Florida versus Isaiah Chance, verdict form. We, the jury, find as follows as to count 1, victim Charles Jones. Check only A, B, C, or D. A, the defendant is guilty of first-degree murder as charged. B, the defendant is guilty of second-degree murder, a lesser included offense. C, the defendant is guilty of manslaughter, a lesser included offense. D, the defendant is not guilty. If you find Isaiah Chance guilty of first-degree murder.
All right, so these are the verdict forms. She's going to start to, we're getting close to the end here. She's going to read each one for each defendant, okay? And again, I'm so sorry for the noise, guys. It appears that the people upstairs are doing their floors. Anyway, we're going to go through each defendant's form right now.
Second-degree murder or manslaughter in count one, you must then answer the following questions. Number one, did the state prove beyond a reasonable doubt the defendant was a member or an associate of a criminal gang during the commission of the offense? Check yes or no. Two, did the state prove beyond a reasonable doubt the defendant committed the crime for the purpose of benefiting, promoting, or furthering the interests of a criminal gang? Again, check yes or no. We, the jury, find as follows as to count two, victim Charles Jones, check only A or B, plus any other specific findings. A, the defendant is guilty of conspiracy to commit first-degree, actually it should be first-degree premeditated murder as charged. B, the defendant is not guilty. If you find Isaiah Chance guilty of conspiracy to commit first-degree murder in count two, you must then answer the following questions. Did the state prove beyond a reasonable doubt the defendant was a member or an associate of a criminal gang during the commission of the offense? Again, check yes or no. Two, did the state prove beyond a reasonable doubt the defendant committed the crime for the purpose of benefiting, promoting, or furthering the interests of a criminal gang? Again, check yes or no. So say we all dated this blank day of May 2026, and there are lines for the foreperson of the jury to sign and print their name. Verdict form, State of Florida versus Sean Gathright. We, the jury, find as follows as to count one, victim Charles Jones. Check only A, B, C, or D. A, the defendant is guilty of first-degree murder as charged. B, the defendant is guilty of second-degree murder, a lesser included offense. C, the defendant is guilty of manslaughter, a lesser included offense. D, the defendant is not guilty. If you find Sean Gathright guilty of first-degree murder, second-degree murder, or manslaughter in count one, you must then answer the following question. One, during the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Again, check yes or no. If you find Sean Gathright guilty of first-degree murder or second-degree murder in count one, you must then answer the following questions. One, during the commission of the offense, did the defendant actually possess a firearm? Again, check yes or no. During the commission of the offense, did the defendant actually discharge a firearm? Again, check yes or no. We, the jury, find as follows as to count two, victim Charles Jones, check only A or B. The defendant is guilty of conspiracy to commit first-degree murder as charged, or B, the defendant is not guilty. We, the jury, find as follows as to count three, victim Xavier Edwards, check only A, B, C, D, or E. The defendant is guilty of attempted first-degree murder as charged. B, the defendant is guilty of attempted second-degree murder, a lesser included offense. C, the defendant is guilty of aggravated battery, a lesser included offense. D, the defendant is guilty of attempted manslaughter, a lesser included offense. Or E, the defendant is not guilty. If you find Sean Gathright guilty of attempted first-degree murder, attempted second-degree murder, aggravated battery, or attempted manslaughter in count three, you must then answer the following question. One, during the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempted to use a firearm? Again, check yes or no. If you find Sean Gathright guilty of attempted first-degree murder, attempted second-degree murder, or aggravated battery in count three, you must then answer the following questions. One, during the commission of the offense, did the defendant actually possess a firearm? Again, check yes or no. And two, during the commission of the offense, did the defendant actually discharge a firearm? Again, check yes or no. We, the jury, find as follows as to count four, victim Gino Norris, check only A, B, C, D, or E. A, the defendant is guilty of attempted first-degree murder as charged. B, the defendant is guilty of attempted second-degree murder, a lesser included offense. C, the defendant is guilty of aggravated battery, a lesser included offense. D, the defendant is guilty of attempted manslaughter, a lesser included offense. E, the defendant is not guilty. If you find Sean Gathright guilty of attempted first-degree murder, attempted second-degree murder, aggravated battery, or attempted manslaughter in count 4, you must then answer the following question. 1. During the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Check yes or no. If you find Sean Gathright guilty of attempted first-degree murder, attempted second-degree murder, or aggravated battery in count 4, you must then answer the following questions. 1. During the commission of the offense, did the defendant actually possess a firearm? Check yes or no. And 2, during the commission of the offense, did the defendant actually discharge a firearm? Check yes or no. We, the jury, find as follows as to count 5, victim Camilla Bentley. Check only A, B, C, D, or E. A, the defendant is guilty of attempted first-degree murder as charged. B, the defendant is guilty of attempted second-degree murder, a lesser-included offense. C, the defendant is guilty of aggravated battery, a lesser-included offense. D, the defendant is guilty of attempted manslaughter, a lesser-included offense. E, the defendant is not guilty. If you find Sean Gathright guilty of attempted first-degree murder, attempted second-degree murder, aggravated battery, or attempted manslaughter in count 5, you must then answer the following question. 1. During the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Again, check yes or no. If you find Sean Gathright guilty of attempted first-degree murder, attempted second-degree murder, or aggravated battery in count 5, you must then answer the following questions. 1. During the commission of the offense, did the defendant actually possess a firearm? Check yes or no. And 2, during the commission of the offense, did the defendant actually discharge a firearm? Again, check yes or no. We, the jury, find as follows as to count 6, check only A or B. A, the defendant is guilty of tampering with physical evidence as charged. B, the defendant is not guilty. So say we all, dated this blank day of May 2026. And again, lines for the foreperson of the jury to sign and print their name.
All right, next.
All right, verdict form, State of Florida versus Rashad Murphy. We, the jury, find as follows as to count 1, victim Charles Jones, check only A, B, C, or D. A, the defendant is guilty of first-degree murder as charged. B, the defendant is guilty of second-degree murder, a lesser-included offense. C, the defendant is guilty of manslaughter, a lesser-included offense. D, the defendant is not guilty. If you find Rashad Murphy guilty of first-degree murder, second-degree murder, or manslaughter in count 1, you must then answer the following questions. 1. During the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Again, check yes or no. 2, did the state prove beyond a reasonable doubt the defendant was a member or an associate of a criminal gang during the commission of the offense? Again, check yes or no. 3, did the state prove beyond a reasonable doubt the defendant committed the crime for the purpose of benefiting, promoting, or furthering the interests of a criminal gang? Again, check yes or no. If you find Rashad Murphy guilty of first-degree murder or second-degree murder in count 1, you must then answer the following questions. 1. During the commission of the offense, did the defendant actually possess a firearm? Check yes or no. And 2, during the commission of the offense, did the defendant actually discharge a firearm? Again, check yes or no. We, the jury, find as follows as to count 2, victim Charles Jones, check only A or B. A, the defendant is guilty of conspiracy to commit first-degree murder as charged, or B, the defendant is not guilty. If you find Rashad Murphy guilty of conspiracy to commit first-degree murder in count 2, you must then answer the following questions. 1, did the state prove beyond a reasonable doubt the defendant was a member or an associate of a criminal gang during the commission of the offense? Again, check yes or no. 2, did the state prove beyond a reasonable doubt the defendant committed the crime for the purpose of benefiting, promoting, or furthering the interests of a criminal gang? Again, check yes or no. We, the jury, find as follows as to count 3, victim Xavier Edwards, check only A, B, C, D, or E. A, the defendant is guilty of attempted first-degree murder as charged. B, the defendant is guilty of attempted second-degree murder, a lesser-included offense. C, the defendant is guilty of aggravated battery, a lesser-included offense. D, the defendant is guilty of attempted manslaughter, a lesser-included offense. E, the defendant is not guilty. If you find Rashad Murphy guilty of attempted first-degree murder, attempted second-degree murder, aggravated battery, or attempted manslaughter in count 3, you must then answer the following questions. 1, during the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Again, check yes or no. 2, did the state prove beyond a reasonable doubt the defendant was a member or an associate of a criminal gang during the commission of the offense? Again, check yes or no. And 3, did the state prove beyond a reasonable doubt the defendant committed the crime for the purpose of benefiting, promoting, or furthering the interests of a criminal gang? Again, check yes or no. If you find Rashad Murphy guilty of attempted first-degree murder, attempted second-degree murder, or aggravated battery, you must then answer the following questions. 1, during the commission of the offense, did the defendant actually possess a firearm? Check yes or no. 2, during the commission of the offense, did the defendant actually discharge a firearm? Again, check yes or no. We, the jury, find as follows as to count 4, victim Gino Norris, check only A, B, C, D, or E. A, the defendant is guilty of attempted first-degree murder as charged. B, the defendant is guilty of attempted second-degree murder, a lesser-included offense. C, the defendant is guilty of aggravated battery, a lesser-included offense. D, the defendant is guilty of attempted manslaughter, a lesser-included offense. E, the defendant is not guilty. If you find Rashad Murphy guilty of attempted first-degree murder, attempted second-degree murder, aggravated battery, or attempted manslaughter in count 4, you must then answer the following questions. 1, during the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Again, check yes or no. 2, did the state prove beyond a reasonable doubt the defendant was a member or an associate of a criminal gang during the commission of the offense? Again, check yes or no. Did the state prove beyond a reasonable doubt the defendant committed the crime for the purpose of benefiting, promoting, or furthering interests of a criminal gang? Again, check yes or no. If you find Rashad Murphy guilty of attempted first-degree murder, attempted second-degree murder, or aggravated battery in count 4, you must then answer the following questions. 1, during the commission of the offense, did the defendant actually possess a firearm? Again, check yes or no. 2, during the commission of the offense, did the defendant actually discharge a firearm? Again, check yes or no. We, the jury, find as follows as to count 5, victim Camilla Bentley, check only A, B, C, D, or E. A, the defendant is guilty of attempted first-degree murder as charged. B, the defendant is guilty of attempted second-degree murder, a lesser-included offense. C, the defendant is guilty of aggravated battery, a lesser-included offense. D, the defendant is guilty of attempted manslaughter, a lesser-included offense. Or E, the defendant is not guilty. If you find Rashad Murphy guilty of attempted first-degree murder, attempted second-degree murder, aggravated battery, or attempted manslaughter in count 5, you must then answer the following questions. 1, during the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Again, check yes or no. 2, did the state prove beyond a reasonable doubt the defendant was...
So again, we're going through jury sheets for each one of the defendants. One of you guys had a question regarding their ages, so I just kind of went through their case files to let you know. Alicia Andrews is 23 years old. She was born in 2003. Isaiah Chance is 24 years old. He was born in 2002. Sean Gathright is 21 years old. He was born in 2005. Rashad is 32 years old. That's the man on the screen. He was born in 1994. Davion is 29 years old, and he was born in 1997. Keep these questions coming. That was a good one.
Was a member or an associate of a criminal gang during the commission of the offense? Again, check yes or no. 3, did the state prove beyond a reasonable doubt the defendant committed the crime for the purpose of benefiting, promoting, or furthering the interests of a criminal gang? Again, check yes or no. If you find Rashad Murphy guilty of attempted first-degree murder, attempted second-degree murder, or aggravated battery in count 5, you must then answer the following questions. 1, during the commission of the offense, did the defendant actually possess a firearm? Check yes or no. 2, during the commission of the offense, did the defendant actually discharge a firearm? Again, check yes or no. So say we all, dated this blank day of May 2026, and again, lines for the foreperson of the jury to sign and print their name. State of Florida versus Davion Murphy, verdict form. We, the jury, find as follows as to count 1, victim Charles Jones, check only A, B, C, or D. A, the defendant is guilty of first-degree murder as charged. B, the defendant is guilty of second-degree murder, a lesser-included offense. C, the defendant is guilty of manslaughter, a lesser-included offense. D, the defendant is not guilty. If you find Davion Murphy guilty of first-degree murder, second-degree murder, or manslaughter in count one, you must then answer the following questions. 1. During the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Again, check yes or no. 2. Did the state prove beyond a reasonable doubt the defendant was a member or an associate of a criminal gang during the commission of the offense? Again, check yes or no. 3. Did the state prove beyond a reasonable doubt the defendant committed the crime for the purpose of benefiting, promoting, or furthering the interests of a criminal gang? Again, check yes or no. If you find Davion Murphy guilty of first-degree murder or second-degree murder in count one, you must then answer the following questions. 1. During the commission of the offense, did the defendant actually possess a firearm? Check yes or no. 2. During the commission of the offense, did the defendant actually discharge a firearm? Again, check yes or no. We, the jury, find as follows as to count 2. Victim Charles Jones, check only A or B. A, the defendant is guilty of conspiracy to commit first-degree murder as charged. B, the defendant is not guilty. If you find Davion Murphy guilty of conspiracy to commit first-degree murder on count 2, you must then answer the following questions. 1. Did the state prove beyond a reasonable doubt the defendant was a member or an associate of a criminal gang during the commission of the offense? Again, check yes or no. 2. Did the state prove beyond a reasonable doubt the defendant committed the crime for the purpose of benefiting, promoting, or furthering the interests of a criminal gang? Again, check yes or no. We, the jury, find as follows as to count 3. Victim Xavier Edwards, check only A, B, C, D, or E. A, the defendant is guilty of attempted first-degree murder as charged. B, the defendant is guilty of attempted second-degree murder, a lesser-included offense. C, the defendant is guilty of aggravated battery, a lesser-included offense. D, the defendant is guilty of attempted manslaughter, a lesser-included offense. E, the defendant is not guilty. If you find Davion Murphy guilty of attempted first-degree murder, attempted second-degree murder, aggravated battery, or attempted manslaughter in count 3, you must then answer the following questions. 1. During the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Again, check yes or no. 2. Did the state prove beyond a reasonable doubt the defendant was a member or an associate of a criminal gang during the commission of the offense? Again, check yes or no. 3. Did the state prove beyond a reasonable doubt the defendant committed the crime for the purpose of benefiting, promoting, or furthering the interests of a criminal gang? Again, check yes or no. If you find Davion Murphy guilty of attempted first-degree murder, attempted second-degree murder, or aggravated battery, you must then answer the following questions. 1. During the commission of the offense, did the defendant actually possess a firearm? Again, check yes or no. 2. During the commission of the offense, did the defendant actually discharge a firearm? Again, check yes or no. We, the jury, find as follows as to count 4. Victim Gino Norris, check only A, B, C, D, or E. A, the defendant is guilty of attempted first-degree murder as charged. B, the defendant is guilty of attempted second-degree murder, a lesser-included offense. C, the defendant is guilty of aggravated battery, a lesser-included offense. D, the defendant is guilty of attempted manslaughter, a lesser-included offense. Or E, the defendant is not guilty. If you find Davion Murphy guilty of attempted first-degree murder, attempted second-degree murder, aggravated battery, or attempted manslaughter in count 4, you must then answer the following questions. 1. During the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Check yes or no. 2. Did the state prove beyond a reasonable doubt the defendant was a member or an associate of a criminal gang during the commission of the offense? Check yes or no. 3. Did the state prove beyond a reasonable doubt the defendant committed the crime for the purpose of benefiting, promoting, or furthering the interests of a criminal gang? Again, check yes or no. If you find Davion Murphy guilty of attempted first-degree murder, attempted second-degree murder, or aggravated battery in count 4, you must then answer the following questions. 1. During the commission of the offense, did the defendant actually possess a firearm? Again, check yes or no. 2. During the commission of the offense, did the defendant actually discharge a firearm? Check yes or no. We, the jury, find as follows as to count 5. Victim Camilla Bentley, check only A, B, C, D, or E. A, the defendant is guilty of attempted first-degree murder as charged. B, the defendant is guilty of attempted second-degree murder, a lesser-included offense. C, the defendant is guilty of aggravated battery, a lesser included offense. D, the defendant is guilty of attempted manslaughter, a lesser included offense. E, the defendant is not guilty. If you find Davion Murphy guilty of attempted first-degree murder, excuse me, attempted second-degree murder, aggravated battery, or attempted manslaughter in count 5, you must then answer the following questions. 1, during the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Check yes or no. 2, did the state prove beyond a reasonable doubt the defendant was a member or an associate of a criminal gang during the commission of the offense? Check yes or no. 3, did the state prove beyond a reasonable doubt the defendant committed the crime for the purpose of benefiting, promoting, or furthering the interests of a criminal gang? Again, check yes or no. If you find Davion Murphy guilty of attempted first-degree murder, attempted second-degree murder, or aggravated battery in count 5, you must then answer the following questions. 1, during the commission of the offense, did the defendant actually possess a firearm? Check yes or no. And 2, during the commission of the offense, did the defendant actually discharge a firearm? Again, check yes or no. So say we all, Dave, this blank day of May 2026. And again, lines for the foreperson of the jury to sign and print their name.
Okay.
All right. Separate crime is charged against each defendant in each count of the indictment. The defendants have been tried together. However, the charges against each defendant and the evidence applicable to each of them must be considered separately. A finding of guilty or not guilty as to one or some of the defendants must not affect your verdict as to any other defendants or other crimes charged. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as email or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I have given in this case, you must tell me by giving a note to the bailiff. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the court deputy while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Okay, so a couple of things. First of all, from this moment forward, I'm only going to refer to you by your initials and your juror number, okay? Just so you know. So the following individuals Juror number 168, Mr. Initials MN. Juror number 213, Mr. Initials JM. And juror number 220, Miss Initials KC. Those three individuals are our alternates. So you will not be participating in the deliberations at this point. Do any of the three of those individuals, you have any items in the jury room that you need to retrieve? Yes. Okay. So what's going to happen is this. All of you are going to go into the jury room. If any of the other 12 that are remaining, if you have any smartwatches, phones, tablets, anything that has internet connectivity, you must give it to the bailiffs. All right. They will keep it out here. They'll keep an eye on it. They'll be fine. The three individuals that are our alternates, I'll need you to go into the jury room, retrieve your items, all of your items, including if you brought a bag, everything you brought, bring it back out here so I can talk to you a little bit further. The other 12 that are remaining, do not begin discussing the case until the bailiffs and the alternates have left the jury room. Okay? Shortly thereafter, you will receive all of the evidence that has been admitted. You each have your personal copy of the jury instructions. However, I gave you copies of the verdict form, but the bailiff will also bring in the official verdict forms that the foreperson will use once you all have reached your verdict. Okay, so that's the form that the foreperson will actually, you all, the jury will use, and the foreperson will sign and date. Okay. Okay. Yep.
This is big, chat. This is big. This is big. They are officially in deliberation. We're a few minutes behind. I'm going to go through my entire trial notebook and talk through the evidence with you guys. We've been tracking this gavel to gavel from day one. So we can talk about some of that evidence, but it looks like they're wrapping up. The jury is officially impaneled. They are in that deliberation room as we speak. Please vote in the chat how long you think it's going to come back.
So I did catch one typo in the verdict form, so I need to clean that up. And so that's why I'm going to send in the official verdict form to you all to use. But you had a sample to read along with, okay? All right, very good. So I need all of you to step into the jury room. Please give all of your electronic devices to the bailiffs, and then the three alternates, please step back outside with all of your belongings.
All right.
All right, it's official. Can y'all get me to 1,000 likes? The jury's filed out. Keep going with the likes. You're almost there. 700.
Okay. Okay, you guys just have a seat real quick. I just have one instruction. Okay, everyone have a seat. Okay, I know that each of you would make an outstanding contribution during the deliberation process. I know that all three of you have been very attentive. Under our Constitution, however, no more than 12, but no less than 12 are allowed to render this unanimous verdict. So I cannot allow you to actually participate at this time during the jury deliberating process. However, I do not know if there is going to be another phase to this trial as we discussed during our jury selection. So what I'm going to do at this time is excuse you from the courtroom, but I will have to remind you that you would remain under the order of this court not to have any discussions with anyone concerning the case, nor to read or listen to any reports about this case, because if the second phase is necessary, I will be asking you to return to participate in the second phase of the trial. Now, we do have that scheduled to begin, if it becomes necessary, next Monday afternoon, okay? And I told you all that we will be done by Friday, May 15th, and we will. So if there is a second phase, it would begin probably around lunchtime-ish Monday and conclude no later than Friday of that same week. We have your telephone numbers. I believe you gave all of your contact information to my judicial assistant and the clerk. If for any reason those numbers have changed, then please let us know, because we will be in touch to let you know if you have to come back, okay? As soon as we know if the second phase is going to be necessary or not, we will contact you by the number you have provided to us. But again, I remind you that you remain under the order of the court. You cannot discuss the case with anyone, and you cannot read or listen to any reports about this case. And no one is allowed to contact you concerning the case other than potentially the clerk or my judicial assistant to tell you you will need to return. So you're being excused from the courtroom, but not discharged from your service yet as a juror. So at this time, we thank you very much. I'm very happy that all 12 jurors remain healthy and we're.
So she is talking to the 3 alternates. There's 12 jury members, right? And they always have 3 backups just in case somebody gets sick or if something happens to one of the regular 12 alternates. So these 3 people, technically, they watch the entire trial too. And because they are alternates, they're not going to be included in the deliberation section, right? But they still need to be available for the penalty phase. And I'll talk to you guys about that in a second.
Able to participate. At this time, I will excuse you from the courtroom, but you are still a member of this jury. Is still under the directions of this court regarding reading about the case, listening to any reports about the case, or in any way discussing the case amongst yourselves or with anyone else. Your notes will be collected and they will be stored at this point. If we do not conduct a second phase, those notes will be destroyed. On a more personal note, I just can't thank you enough for the service you have done so far. As I stated, under the law, we have to have 12 people to decide these cases. And you all see how much work goes into these cases. If we had a juror that got sick, had a family emergency, and had to drop out, and we didn't have an alternate in place, then I'd have to declare a mistrial, and the whole thing would have to start over. So I hope you all do not feel that your time has been wasted in any way. You may be disappointed, you may be elated, I don't know. But that's why it's so critical that we have alternates. And that's why it's so critical that if we go into the penalty phase, we've got to have alternates again that are able to step in the event one of the other jurors has to drop out for some reason. So the good news is you're free for the weekend, right? That's the good news. You're free for the weekend. So we will be in touch if we need you. And thank you all so very much for your service to date. And if we do not go to second phase and you do not need to return, again, on behalf of everyone, we thank you so very much for your service. We're so grateful for citizens like yourselves who volunteer to serve on these cases. We really are. So, all right, very good. You're excused from the courtroom for now.
All right.
Deliberating as of 10:25 a.m.
Okay, very good. So I need to get the verdict forms tidied up and sent back to the jury, and then, oh, okay. or may already be done for me, and then we'll take a 10-minute break and we'll come back and I'm ready to roll on the motion for mistrial, okay?
All right, so there's still quite a bit to get through. It looks like they took a break, so the jury is officially in the room deliberating right now. Now, if you guys remember yesterday, Davion's attorney, Father Time, he stood up and submitted a motion for mistrial. I do have Davion's case file up here. It looks like the motion for mistrial was submitted on the 7th, which was yesterday, but the document is not yet available. So, usually they'll have these things, but because it's such a high profile case, the document isn't up yet. So Mr. Sonardi, who I call Father Time, is about to argue that motion. Yes. Okay. So document number 5569, defense oral motion for a mistrial was taken under advisement by Judge Sisko. We're going to be able to skip through this break real quick and see what Father Time is motioning for mistrial for. Like, what's the reason behind that? And then I did find this. So I was able to find a stipulation that they agreed to regarding Davion's tattoos. So I don't know if it has something to do with this guy right here, but apparently they came to an agreement to this stipulation that Davion and the state of Florida, they came to an agreement that his tattoos included the 1200 block tattoo on his neck was obtained before January 15th of 2021. In addition, he wrote the rap song in State Exhibit 85 on April 19th of 2019. We hereby certify the foregoing stipulation is made in good faith and reasons herein. So it looks like Michelle, the woman that did closing yesterday, signed this document. Looks like the 6th, and then Father Time signed it, and then Davion's interesting signature is also here as well. So that's the latest in his case file, but let me skip ahead to see the motion's going to get denied. Like, I'm going to tell you guys straight up, like we've gone 10, 11 days throughout this trial. It's going to get denied. Oftentimes they do get denied, but let's see what the rationale and the reason behind it is. And then as a special treat, since you guys have been rocking with me, you're not going to find this anywhere on the internet. I'm going to go through my entire case notebook and talk about every single witness, all 35 witnesses, the information that came out. This is all of the stuff that the jury is going to be deliberating on. All right. So we're going to kill a little bit of time by doing that. And because I've put in all the work and research on this, really would love for you guys to get me to 1,000 likes, and you'll be able to kick back, relax, and hear all the evidence, because that is what the jury is doing right now. They're going to have to go through everything. Okay. So we're going to go through it together, but do me a favor and get us to 1,000 likes, and then we'll get started on that. Okay. Let's see what the motion for mistrial is all about.
Davion Murphy, mistrial, and had him separated from the other defendants, and would move for that.
Okay, very good. State any response?
Yes, Your Honor, just that during the course of the statement, the state agrees obviously that the statement itself was inappropriate, but not such rising to the level.
Okay, hold on. What statement? Let's go back. So it looks like there was a statement that was made that Father Time believes was unfair or prejudicial to his client, Davion Murphy. And because of that statement being made, it looks like ChatGPT, Anna Ismer, I call her ChatGPT as a compliment. She's very sharp as a lawyer. I want to see what the state's response is going to be. But because of that statement that was made, Father Time believes that it warrants a mistrial and Davion should be severed from this group. It's a Hail Mary. It's not going to work, but let's go back in.
Had him separated from the other defendants, and would move for that.
Okay, very good. State any.
What
We submitted,
talking about?
and
We're going back a little bit. I just want to hear the entire sentence. Okay, here we go.
Okay, is there any additional argument on the motion for mistrial, Mr. Sonardi?
no additional argument, Judge, other than we were agreed to stipulate to the jail photos of Mr. Davion Murphy to avoid the testimony of a DOC individual coming in. We went to great lengths to avoid the jury being knowing Mr. Murphy had previously been incarcerated, and the detectives clearly said while in prison in the presence of the jury, and we submit that that's sufficient to grant Mr. Davion Murphy mistrial and have him separated from the other defendants, and would move for that.
Okay, very good. State, any response?
Yes, Your Honor, just that during the course of the statement, the state agrees obviously that the statement itself was inappropriate, but not such rising to the level that it would vitiate the entire trial itself or support the need for a mistrial. The reference itself was an isolated incident, and in the context of the trial itself, it should not result in a mistrial. It was an inadvertent statement and certainly did not become the focus of the detective's testimony, and certainly not the intent of the state in my review of that testimony or that portion of that testimony to elicit anything about prison itself. In re-listening to that audio as well, there was no further reference to it, and it did not become a focus of the trial.
Okay, very good. So there's a case, in my opinion, almost directly on point, State versus Jenkins, 391 Southern 3rd, 510. It's a second DCA opinion from June 12th of 2024. And in that case, it was an ineffective assistance of counsel claim, alleging ineffective assistance because defense counsel did not move for a mistrial. But in the context of that, the second DCA stated as follows. In that case, the witness was asked about the defendant's hairstyles for identification purposes, and the witness responded, quote, dreads before, he had little twists before, when he came home from prison, he had a short haircut, close quote. The second DCA in that case held that when a defendant moves for a mistrial based on the improper admission of collateral crime evidence, the motion is addressed to the sound discretion of the trial court. And while evidence of prior criminal activity is presumptively harmful, an isolated or stray reference to a defendant's prior incarceration is considered in context of the trial and does not necessarily result in a mistrial. The witness's statement was isolated, inadvertent, and not focused upon. And it is clear from the record that the state did not intentionally elicit the information from the witness, and that not everyone heard the witness's statement. Similarly, in Guzman versus State, the Supreme Court of Florida opinion 214 Southern 3rd 625 from 2017. The Florida Supreme Court stated the standard requires that a mistrial be granted only when an error is so prejudicial as to vitiate the entire trial, such that a mistrial is necessary to ensure that the defendant receives a fair trial. Even if the jurors might have inferred that the defendant in Guzman was jailed for a different crime, the reference to the jail was brief, isolated, inadvertent, and not so prejudicial as to vitiate the entire trial. A comment regarding a defendant's prior imprisonment that is brief, isolated, and inadvertent may not warrant a mistrial. In this case, I find that Detective Griffin, was it Griffin or Griffith?
Griffin.
He sua sponte just blurted it out when he was discussing Davion Murphy's tattoos, when he was discussing his knowledge of when Mr. Murphy got them or did not get them. He just blurted out these he got in prison. The state did not elicit that response from him. And I do find that it was a brief, isolated, and inadvertent comment, and that it is not so severe as to vitiate the entire trial. So I'm going to deny the motion for mistrial.
Thank you, Your Honor.
All right, and let's talk a little bit while we're all gathered together about sequestration. Okay. I get this question every capital case I do. So this is what the rule states. And I'm reading Rule 3.370, regulation and separation of jurors, A, during trial. After the jurors have been sworn, they shall hear the case as a body and within the discretion of the trial judge and may be sequestered. In capital cases, absent a showing of prejudice, the trial court may order that between the guilt and penalty phases of the trial, the jurors may separate for a definite time to be fixed by the court and then reconvene before the beginning of the penalty phase. Subsection B, after submission of cause. Unless the jurors have been kept together during the trial, the court may, after the final submission of the cause, order that the jurors may separate for a definite time to be fixed by the court and then reconvene in the courtroom before retiring for consideration of their verdict. C, during deliberations, absent exceptional circumstances of emergency, accident, or other special necessity, or unless sequestration is waived by the state and the defendant, in all capital cases in which the death penalty is sought by the state, once the jurors have retired for consideration of their verdict, they must be sequestered until such time as they have reached a verdict or have otherwise been discharged by the court. Okay, so that includes guilt and penalty phase. I get that question every time. Includes guilt and penalty. Jury must be sequestered unless the parties waive it. Okay?
Thank you, Judge.
All right, very good. Thank you.
Thank you.
Okay, let me just check Twitter for any updates before we move on. Looks like they're impaneled as of 10:25. So there's nothing new from the executive team at Law and Crime. I'm gonna put us all the way live with the live feed. Okay, I'm just realizing this, chat. So I'm gonna do my best here. I'm gonna give you a synopsis of everything we just heard. I don't know why they decided to do it today. And I don't know if this is just luck or whatever the case may be. But it seems as if literally the apartment on top of me, they're replacing the entire floorboards. All of the floorboards are being replaced. So you're going to hear some banging, all right? Like you could probably hear it right now. If it becomes intolerable, I'll probably have to record all this evidence separately. But I'm going to try my best, okay? You're just going to hear all that banging in the background, and I'll keep the mic low so that way it's not too hard on the ears, okay? But I do think it's important to go through all of this evidence from April 22nd all the way to now. You guys hear it? You hear it, okay. Well, listen, here's what the game plan is for today. So right now the jury is doing their thing. They're in the room and they are deliberating, okay? They have their verdict slips. They have all the evidence in front of them, and they have to begin talking about all the evidence in the case. Some of you guys asked about the ages of the defendants. Alicia Andrews is around 23 years old. Isaiah Chance is about 24 years old. Sean is about 21 years old. Rashad is 32. And Davion is 29. Once we get a verdict back, which is likely going to either be today or tomorrow, right? And that's why she just talked about sequestration. Like, how long are these jury members on the hook, right? They are on the hook to deliberate for today, possibly into tomorrow. And then we go to phase 2 of this trial, which is the penalty phase. Anybody that is found guilty for, the murder of Julio Foolio, we'll have an opportunity to bring in witnesses. And this is why you don't see a lot of friends and family in the room right now, because those people are penalty phase witnesses. All of next week, we'll get a heavier courtroom, but we went through it yesterday to see how long they would take to ask the judge to give them a lighter sentence. Rashad is going to take about 3 hours. Davion is going to take about 2 hours. Sean Gathright is going to take between 3 to 4 hours, and Isaiah Chance has the most time. He is going to go for 4 to 5 hours. We have those witness lists. She reminded them yesterday to make sure that they tighten up those witness lists, and we'll go from there. Let me see where you guys are on the poll. This poll, we're going to leave up all day while I'm here. How long for the verdict? It's actually tied, chat. I did not expect that from y'all. 40% of you guys think we're going to get it this afternoon. So if they just started and their meals are going to be delivered to them. So they're going to have lunch and be deliberating. Okay. They're not going to leave that room. 40% of you say that we're going to get the verdict this afternoon. 40% of you also tied say that we're going to get it this evening. If you remember Alicia Andrews, her verdict came in around 10 p.m. 11% of you say tomorrow morning, and 9% of you say tomorrow afternoon. Okay, so it's going to be very interesting. Let us come to the top of the book here and see all of the notes that we've been taking for this trial, starting with the state's opening statement. As you guys know, Mr. Harmon gave the state's opening statement. This was day one, right? And he kind of mirrored what he did for the opening statement of Alicia's trial. He gave the opening statement in that one as well. He talked really a lot about Foolio, who he was as a person, this young man that we lost, okay? 26 years old. It was his birthday, and he didn't even make it many hours into his 26th birthday, okay? But he talked about how this was a stalking. It was very premeditated, this plot, this collective evil to hunt him down, right? They talked about Isaiah Chance, Sean, Davion, and Rashad, and how they worked together to coordinate and plan this out. Now, the other thing that he did is he talked through some of the previous gang war timelines. So he started with Spaz and how that happened in October of 18. He talked about Bibby and how that was in February of 19. He talked about Jake Jit and how that was August of 23. Little Kobe, who was also August of 23. Tilly, October of 23. And then a few hours later on that same day, the first attempt on Foolio's life in October of 2023. Okay. Gave you a little bit of background on drill rap, what it is, bringing in Young and Ace and going back and forth with those songs, right? Like When I See You, and also the Young and Ace songs that were made before and after us losing Foolio. They talked about how this time, very different from Alicia's trial, there was way more digital fingerprints and digital evidence, okay? They talked about the flock safety reports, what they're using on highways to track these cars and look at license plates. And that's how they were able to use digital forensics to track how these cars were moving in tandem with these cell phones, okay? So they were talking about that. It also showed when they arrived in Tampa from Jacksonville, okay? So the 739 arrival, and then another car arrived at 746, Keisha's car. So they were literally minutes apart from each other, but on the highway, those cars were traveling almost at the same time. Talked a little bit about some of the other victims in this case, and that is something we talked about yesterday with the attempted murder options as well. So not only did we lose Foolio, you have Gino Norris, you have Xavier Edwards, and then you also have the young lady, Camilla Bentley. Oh my God, it's gonna be hard. Camilla Bentley with the attempts on their lives as well. Even though they were with Foolio at the time, all of that was kind of happening at once. They talked about Rashad Murphy and the issues that Rashad has as far as evidence. I mean, I don't know how Gonzalez thought he was going to try to beat this case, but we'll see what happens. Rashad was referred to as the ghost, right? And when they went to that Airbnb, you don't see him on camera, but there's a lot of other evidence that puts him in that space. We go to 1:40 a.m. and we look at the McDonald's footage where Davion and Alicia are clearly in the camera, right? We learned that Isaiah was in the back seat, although he is not seen on camera. They ordered a lot of food, so it was definitely for a lot of people. But it is interesting because do y'all remember when Davion's interrogation footage was shown and he said that he didn't know them? What I'm just now piecing together is like, bro, you said you did not know anybody that was in that house, but you're driving the Chevy Cruze and Alicia's in the front seat. That just came together for me. Especially if you're saying that you've never met these people before, but you're driving the girl to McDonald's to get food. That falls on its face. Anyway, they talk about Isaiah, the little pink iPhone, the masks that were happening when they were outside of the nightclubs and kind of scouting before the Chevy Impala made its way over to those locations as well. Another thing that Michelle Doherty mentioned in closing yesterday that was interesting was they could have, like if they were really hunting Foolio, they could have, attempted to do this outside of the nightclubs. Notice that they didn't. They wanted to wait where there were less people around, less cars around, kind of waiting a few hours after, because that would have been chaotic and this crime would have been a lot bigger if they, decided to do what they did outside of those nightclubs, but they didn't. They were really taking their time here, right? The phone data definitely cooked them. It was a coordinated effort with the cars. You see them blowing through the red light and circling the hotels. They did show that map. I didn't like that map, but it does show the position of where these cars were. And then he talked about how they got sloppy on that ring footage, right? That's when everything just started to fall apart because they were all being shown on the ring footage, but when they got there, they were going through the back door. Let's see, what else do we have here? The Uber ride back. So, that ring footage from the Airbnb, them getting into an Uber, the Uber driver being very cooperative with law enforcement in this investigation is another big thing that cooked them too. And then I do like that Michelle called them murder vehicles because again, that Chevy Cruze it was bought back to Georgia, right? Like they were trying to get it out of the state of Florida and they bought it to Georgia. Okay. So there was that thing. And then you guys know that Sean was trying to hide that black car and swap it with his grandma, putting it in the garage or whatever. It's crazy work how they did that. But it was just the speed and violence of the action. Like all of this took place so fast and they were trying to get through everything rather quickly. Sean's iCloud also cooked him. In the hearings leading up to trial, I would say beginning of April, Sean was fighting very hard to keep his iCloud information out of the case. Now you see why. You saw that day when he was looking in between apps and he's looking at, Zillow.com. He's looking at, Foolio on Instagram. And then on top of Zillow, he's looking at Airbnb because he was so determined to find that address. I think for me, that was the biggest piece of evidence in this entire case was that he was so determined. Like we saw that screen recording for like 5-6 minutes of him trying to find that address of where Foolio was. And then for them to say in closing arguments, oh, well, that was at 8:00. It's not a big deal. No, listen, it is a big deal. It is a big deal. It showed how focused he was on finding that address. So I thought that was a huge thing as well. We did learn about the text message to Kyla at the beginning of the, in Alicia's trial. We did learn about the text message where Sean was messaging his girlfriend and his sister and saying, hey, tell Fat Boy you want to see him. Try to figure out where Fat Boy is. That also kind of coordinates what we have on Sean, Coming to Rashad, the whole left-handed thing, I could not believe this boy was in front of the jury as Michelle looked at the jury and said, she looked at them and said that the shooter number one, which is presumably Rashad, is left-handed. Why was Rashad at the table writing with his left hand? That was crazy work, but he did that yesterday and that came out way back in the day. Like on April 22nd, they talked about this left-handed business, right? We have the Walmart footage where he's wearing the same exact clothing that he was wearing the night of the shooting. And although they're like, okay, well, the faces are covered, you can't tell that it's the same person. It's Rashad. It's his build. You can see it. It's his boots. Same boots. We know it's Rashad. And Rashad lied a few times about being in Tampa in the first place. So Rashad has a big mountain of evidence against him, using his brother's baby mama's car to get this done in the first place is crazy. And then they're talking about how all of this started because he was upset that Spaz was lost, right? Isaiah, they have a lot on the phone with him. The big rumors about him being homosexual came up, and the Twitter Spaces I think is what's going to cook Isaiah, because Isaiah went to that discussion. He saw Foolio in that discussion. Foolio really didn't want to engage in that discussion, but Isaiah came in and was being disrespectful and kind of started that altercation. At the same time, when that's happening, it's public. Everybody can hear it and see it. At the same time that's happening, a discussion between Sean and Rashad is happening on the side. And they're like, hey, try to calm him down. Start trying to talk him off of the ledge. Like, we got bigger fish to fry. So that's the other thing that cooked Isaiah, because it's showing that your friends are trying to get you to calm down. You know what I mean? So that big thing happened as well. Davion's interrogation footage is pretty damning for him. He lied. But I think the biggest thing in Davion's interrogation footage is he kept saying, how did they find me? How did they find me? Like it was like 2 hours long, but he kept saying, how did they find me? So that proves that you knew what you were doing and that you were hiding. You were hiding for 7 months. So, I wish that Michelle kind of harped on that a little bit yesterday, but she didn't. But it's okay. So that concluded the state's opening statements and the biggest, almost like previews of evidence that they gave to the jury on day one, right? Then all the defense attorneys gave their opening statements, very, very light here. Isaiah talked about how a lot of this was just speculation and how he's not the principal and there was no conspiracy to murder. He admitted to some proof of communication, but his attorney kept saying that he didn't have the specific intent and at no time you could place him as a driver of any of these vehicles. But he did admit that the gun was in his possession at Sean's house, outside of Sean Gathright's house, and you saw the ring footage. I don't think that was a ring. I think their surveillance footage show Isaiah pulling the 9mm out of his car and putting it in his waistband. So he got in front of that. That gun was never recovered, but 9mm shell casings, 31 of them to be precise, were found at the scene. Okay, but he did admit that the gun was in his possession. Coming over to Sean Gathright, I mean, y'all heard about this pressure washing business, allegedly. We know that his mom was the Marine, had access to all of those very dangerous guns, the bullets, the shell casings in the safe, the text messages regarding Fat Boy, the sink stuff, like the stuff that was recovered in that sink, the gold car, things that just matched from October, where Julio's, the first attempt on his life was made. Those shell casings are very damning on Sean. But also, Sean's approach in that opening statement was, do these casings match? Do these ballistics match? And they did try to, kind of take the state's case apart with the matching. And we saw that on a lot of the different cross-examinations. I don't think it's going to work. And they had the most objections in their opening statement. I think there were about 4. So again, the state was on top of it. Coming to Rashad. Rashad's opening statement, Gonzalez gave us such a headache. It was really like, dude, make it make sense. And I think that's what I wrote down here. Gonzalez was saying that to the jury, like, oh, make this make sense. And it's just like, okay, I guess. He tried to really just separate how Rashad is different from the other individuals, that he's not guilty, and he wanted to sever from the beginning. If you guys know, Rashad was originally going to represent himself. Gonzalez mentioned that he had no presence. He was not in Tampa at 4:40 a.m. And we all know that that's not true. He was. He was saying a lot of it is circumstantial evidence and that he was just a part of the entourage. He wanted us to really focus on Robert Howard, Kenny Caps, and, just mentioning that Rashad may or may not be taking the stand. It was very short. Then we go to father time for Davion Murphy. He talked about the McDonald's footage. He admitted that, was saying that he is not a suspect or a defendant in other cases. Talked about the Airbnb. He was casting doubt on that. What about the way that the shooters were dressed, that sort of thing. We also learned in their closing argument yesterday that Davion is left-handed, and they tried to say that the shooter 3, who is presumed to be Davion, is right-handed. I don't know if that's going to stick or if it's going to work with the jury, but it's very, very light for their opening statements. Now let's get to the witnesses. First witness was a Tampa cop, and I believe we had a few unis the first day. So on day 1, this cop found Foolio and then was following a blood trail where they went into the hotel and found the other 2 victims. They went to different rooms. It looks like, I don't even know how these boys were shot like that, and they were on the first floor, and then they went to the third floor, and they were just trying to get into different rooms. Like, they had to be in pain. And I think one of them realized he was shot, and the other did not realize that he was shot. So, they got them medical attention and went from there. So that was the first Tampa cop who was following the blood trail. The second one was another uniformed officer. He kind of surveyed the scene and recovered most of the shell casings, secured the area, made sure that nobody was attempting to come in or out, and protected the crime scene. And then just, they did talk about this, where they were trying to say that some of the victims were uncooperative. So I wrote down Robert Howard, Miss Randolph, and Armani Turner. I think they were trying to say that Armani was uncooperative. And if you guys remember, Armani was dating Foolio at the time, and she was the driver of one of the cars. Okay, so I believe her girlfriend, Miss Randolph, was in the car with her. We have another uniformed officer, witness number 3, who was also at the scene. He is the one that actually spoke with Gino Norris and Xavier Edwards, realized that both gentlemen were shot in the arm, and just kind of talked about that, got them medical attention, and, discussed where they were in pain, things like that. And then they interviewed these guys while they were getting treatment. So they talked about that, went back to the scene, and started to kind of count how many bullet holes were in the black Charger, and getting some information from the victims on what happened. Witness number 4, also a uniformed officer, same thing, no cross-examination with that one, but just kind of talked about securing the scene. So we had a lot of folks from Tampa PD on the first day. Detective Alverson came up as witness number 5 and just talked about, from Tampa, what the initial investigation looked like the day of. That came with collecting the shell casings, looking at the stamps and markers and manufacturer of the casings that were recovered from the scene. Sean's lawyer, again, because all of that heavy weaponry was recovered from Sean's house, I think one of the biggest mistakes in Sean's defense is that they are assuming that people know about guns on that jury. Not everybody does, so I did jot that down back then on day 1. But they did talk about how the Dodge Charger was secured, the property damage that was done to the hotel, like a fully booked hotel with families that were there, some of the bullets that flew through windows and almost hit some of these hotel guests was crazy. So they talked a lot about that. ATF was called. And it seems that the shell casings were collected by Tampa PD at first, and then the feds, ATF, got involved to help secure the shells at the scene. Talked a bit about the autopsy. We do have a doctor that talked about the cause and manner of death a little bit later, but also we learned about other vehicles that were damaged. So the Lexus, the white van, in addition to the Dodge Charger, and the property damage that was caused to the hotels. So there was so much damage. So, in addition to all of this, you have to really think about these boys putting other people's lives in danger. You know what I mean? They think that they're doing this on a quiet street or whatever, or in the middle of the night, but you actually have all these people sleeping in the hotels as well, where, you're causing imminent harm to other people that are literally in their sleep. You know what I mean? So if you just think about the property damage, and y'all know these little boys don't have no money, but all of that was happening. So cross-examination on that one, I thought, was very weak. They kept talking about the defense is built on matching, and if these things match, right? We got to the Tesla footage and we were able to see that. And that was the first time we saw it. Moving forward, we had witness number 6, Miss Randolph. She was Armani's friend. And remember, Armani was Foolio's girlfriend. She mentioned that they've been friends for 7 years, and she talked about the placements of the cars, right? So the Nissan, the Charger, and then the other vehicle as well, and how who was sitting in what car. So in the first car, you had Aaliyah, Taifa, Camilla, right? Camilla, one of the victims. In the Charger, you had Xavier, Foolio, and Gino, right? And then you had Armani Turner in the other car as well. So we just started to learn more about the scene and what it was like from all of them, okay? They also talked about just the movements. You know, they went from the Airbnb to the first club, then to the second club, and then the hotel, and why they were kind of out there in the first place, because they were looking for accommodations. And I believe their room was given away. So that was the only reason why they were all outside kind of sitting. And then Aaliyah and Taifa had gotten out of the third car and they went inside to go to the bathroom or whatever the case may be. So one of the girls was left alone in that vehicle. Witness number 7 was Gino Norris, one of the victims. Now, this is important too. Xavier didn't testify, but Gino did. Okay, so Gino was there. He mentioned how close he was with Foolio, Kenny Caps, Taifa, how he knew Taifa, aka Tata. Cross-examination. I thought Rashad Gonzalez tried to go in on cross on him. He was just like, you bought a gun with you, right? And then asked him like silly questions like, what is 6 block? But here's the other thing that we found out from Gino. Yes, Julio and team were strapped. They had guns with them, but I believe they were in a different car. I think they were in Taifa's car and not in Julio's car, right? So I think they were trying to cast doubt and show, well, y'all were strapped too, but at the same time, everything happened so fast that there was no time to react. There was no time to react, so I think that cross just failed on its face. Davion's attorney, Father Time, came up and said, they didn't like Foolio because of his music, right? Or something like that. That was silly. Sean Gathright's lawyer, do you know Sean? Like, that didn't help. Isaiah saying same thing. Do you know Isaiah? And basically Gino's like, no, I don't know who these dudes are. I have no idea who they are. So Gino, witness number 7, wasn't up there for a long time. Camilla Bentley was there for a little bit. Short. She was witness number 8. It was very, very, very short. She mentioned how she was friends with Aaliyah Albritton. And again, Camilla was one of the victims. So a lot of this was focused on her health, where she was shot, how she was feeling, how she escaped, things of the like. Now, they did cross her. Just 2 attorneys crossed her. Sean's attorney and Isaiah's attorney. Sean's attorney is like, do you know Sean? And do you know who Fat Boy is? And it's like, that's not really helping your defense, but whatever. Poor girl was shot and she did not expect that to happen. Next, we had one of the, so who was that? Camilla was number 8. Witness number 9, Audra Adamente. She was one of, I'm not going to call her a victim because she was not harmed, but this was a woman who had her daughter moving into college across the street at the university. And she was in the room with her husband and the daughter's boyfriend. So they were talking about where their room was. And for this family, not only was, bullets flying through the hotel room that they were staying in, but the minivan that they rented also sustained some damage. So that also goes to show what these boys did and how their actions like impacted people, right? So you have that. She wasn't up there for that long. Witness number 10, Officer Douglas came in. He is a uniformed officer. He just talked about the southwest corner of where the shell casing of the property and where the shell casings were found. He focused more on the fence line and where the Tesla was. And he also interviewed a few people. So very, very short. Witness number 11, Mr. Pablo. Y'all remember Pablo. Pablo was another hotel guest, was there with his family visiting the zoo. Just kind of talked about how, he had his family get on the ground when the shooting was happening. And he had a little boy in the room along with his wife, and he had his kid get on the ground when this was happening. And, I think really that was to show the effect of the families that were staying in that hotel that night and didn't know what was going on. Pablo didn't speak English, so his testimony was in Spanish. Next, witness number 12, you had Aaliyah Albritton. She was there with Taifa. She was in the car, but she ended up getting out of the car and going into the hotel to use the bathroom. So she heard the shots outside. And then, they tried to cross her and kind of discredit her a bit, asking why she was taking selfies instead of going outside to see what was happening. And kind of going from there. We also did learn that she used to date Young and Ace's little brother, Quan. I don't know how that's relevant, but that did come up as well. They also asked about, how much she had to drink that night to see if she could recall information correctly. And then also there was something about her being on probation, and that's why she didn't want to talk to the police officers. So they try to discredit her, but overall, her witness account is important because she was actually there. We go to witness number 13, Tampa PD, and this is another uniformed officer who responded to Pablo's room and recovered some bullet fragments from that room. Very, very short witness. Move on to witness number 14, Detective Oliver from JSO. So really just talking about some of these cold cases from the past. So, Bibby's situation, Adrian Gaynor, and then he did talk about Queso and then the ATK conviction with Queso that happened last year. So very light, and that was the first day. We then move on to Jacksonville detectives the next day, and they talked a lot about those historical 6 incidents. Detective Nieder came in at this point and, just mentioned how they talked to other victims of these crimes. And we then start to learn about Davion having some of these tattoos, the 1,200 tattoo, things of the like. Detective Nieder was there for a while. He was witness 15, and he specialized in investigating ATK. Gave them, kind of gave the jury some groundwork on what ATK is, common enemy of 6 Block, and just talked about how they investigated and monitored ATK. So whether that meant checking out Apple Music, things of the like, monitoring these music or these videos that are back and forth disses towards each other, things of the like. Now, I don't know. This is when Father Time. I don't know if y'all remember this. They were asking about how do you track the music? And, I think Detective Nieder was just like, they're posted on the internet. And he's just like, well, how do you do this investigation? Like, do you go to Google and look for it? And this is when Father Time was like, seemed to be confused and asking the detective if he can edit things that are on Google. And I'm like, okay, that's interesting. But, I didn't really get that far. The idea of putting witness 15 in the placement in which they did was to come away from the crime scene and start laying the groundwork for why these 2 groups were going back and forth, right? So that was the purpose of it. I talked about how many gangs were in Jacksonville at the time. They said that they had 30 that were documented. Isaiah's lawyer was asking when, these folks were documented as gang members. And, I think he was really just thinking about, the gang enhancement that was coming. So that's why he was asking those questions. Like, how do you guys document these gang members? When was my client documented as a gang member? Things of the like. We then moved on to witness 16. This is when we go to Rashad's fried balls. Okay, so we now have the Georgia police officers that talk about Rashad's arrest, because Rashad had 2. He had been arrested in Georgia, right? I believe it was in Lawrenceville, Georgia, in Gwinnett County. And they talked about how he was stopped and why he was stopped, okay? So this patrol officer was just on duty, regular day, and he gets the flock data request. And this was coming from Detective Ramos looking for that Chevy Cruze, right? They put a felony request on that car. On the plate number. If anybody sees it, even if you're in another state, stop that car. It was involved in a felony. Okay. At first, it came up on a license plate reader, and the car was reported as stolen, but it should have just been categorized as a felony vehicle. Now, this officer in Georgia gets a hit on the car, and then he stops Rashad. Rashad is stopped, but instead of cooperating, Rashad immediately gets out of the car and runs. Now, this officer dispensed his taser. The first hit did not connect to Rashad's body, but the second one did, and it connected to, his private area. Another cop runs up, puts a gun to Rashad's head, and tells him to stop moving and to cooperate, right? I think that Gonzalez was trying to focus on that arrest, but that's not the core of this. It also, the car is also flagged as a felony vehicle used in a murder. You know what I mean? So they were trying to come at him on cross and just say the way that they handled things was too aggressive. But at the end of the day, he ran. He got out of the car and he ran. He did not cooperate. Now, in that, once he was detained, they did a search of the vehicle. They did find the cell phone in the car. And that cell phone was shared with Charmaine Steiger, Rashad's baby mama. I don't know why they share a cell phone, but that came up. And they talked about the taser and the connection and all of that stuff. Next up, you have Detective Carter. This is the woman, I believe. She is also a Georgia police officer, and just talked about once they received the phone, right, Rashad's phone, how they kind of conducted a search and the data that was extracted from that phone. She also helped introduce the information from Walmart and showing that he purchased another phone. So that was the first time that we saw that. Now, on this phone, the Cellbrite report had a few pieces of evidence on it. There was some screenshots of Foolio's Instagram account on this shared device, so we were able to see that. And she talked about how it was shared to Tampa. There was also this idiot's license, a picture of his license. He kept saying that he doesn't know how the Airbnb got booked under his name, but like his license was used to book it, like whatever. All of that came out here. And then we also have that picture of what he purchased from Walmart. And it was the bag, like the cell phone, whatever. And it came up in closing arguments yesterday that these are the things that he bought at Walmart, but it was actually, he was supposed to take it to Orlando he was going to smuggle it into a jail for his brother, and those items were purchased for his brother, and that's why he rented the car. But then we zoom in and notice that there, like when you zoom out of that picture, you could see the handle of the gun and his boot. Like what and like that was a dumb move in this trial, because if you think about it, Gonzalez wanted that photo like to be enlarged. And it kind of was a double-edged sword, because what did we see? The gun handle. It's like, oh, well, thank you for this evidence. It's just, thank you so much for this evidence. Great job. So other than that, he talked about how Rashad was released from jail that day, and they talked about the wireless charger and how that evidence, right? They didn't have a full cell phone extraction. It was partial because the phone was damaged and it died. I don't think that that's going to even impact the jury's decision here, because look at what came out of the partial extraction. Look at all of that, So those were some pretty big pieces that came out of that. Next, witness number 18, we go to Detective Klein from Tampa Police Department. He had the search warrant to go through Alicia Andrews' phone. So we talked about some of the business surveillance as well. They were tracking Alicia Andrews' phone. Alicia's phone was, they had, I believe, T-Mobile information from Cellbrite and Cellhawk. So they were able to use her phone to track the cars, right? So they were able to see the silver Chevy Cruze and the black Chevy Impala, and then use Alicia's phone to see where their movements were. So between the McDonald's, between Truth 18, and between the second club as well. The defense attorneys, 3 of them came up for cross-examination on this one, and they tried to just say that the Cellbrite and Cellhawk reports are not accurate, that they're not always pinging off the right cell towers, and how are cell towers determined, and it needs to be between 1,000 meters. But we learned that these reports are indeed accurate, because not only did they use Alicia's phone, they used the other phones, and then they were able to use more digital footprints to verify the actual reports for accuracy. And then, they just asked a lot of questions about the error rates with these type of reports and things of the like. They're supposed to do this. They're criminal defense attorneys, so they're supposed to cast doubt. But we all know that Cellhawk and Cellbrite, these are industry standard. Like these reports are accurate. So it is what it is. That was Detective Klein. We now go to witness number 19, which is Detective Ramos. You guys know there's so much that comes out of Detective Ramos, because he is the lead detective in this case. So, he talked about Julio's movements first, right? Why was he in Tampa? He was celebrating his birthday. We went through some of the posts where, he was there for a paid performance as well. So he's also there for business in addition to celebrating his birthday, right? You talked about the subpoena between Julio's IG records, right? So we were able to see him post these things, and that's how they went from there. We had Detective Ramos talk through his investigation and where it started. And it started with understanding who this silver Chevy Cruze belonged to. So he started running plates there and got Jasmine Glennon, who is related to Shaheem Murphy. And then that's what led him to Rashad, right? Then after Rashad, after this car, he kind of tracks the movements between this silver car. Then once we get to Rashad, we get that Rashad is the one that booked the Airbnb. We get to the Airbnb, and then you can go to the Airbnb person and look at the footage and see who is on the ring footage and kind of track like the locks as well, because that's how he found out that Alicia wasn't just there by herself. Other people had to be in the house to either let her in, and looking at the different movements between who booked it, how they got there, who was in that house, right? We also looked at the gold Toyota 4Runner, tracked Sean's movements because Sean was on that footage, and they used the forensic tracking to do all of that. Talked a little bit about some interrogations. I think the first one was Isaiah's and how he was there for 2 hours and 13 minutes, had been Mirandized when he was arrested, admitted to using another phone, talked about being with Sean, admitted to going to the McDonald's, admitted to going to a club. That came up in Alicia's case, but we also found that Isaiah or Alicia, I think it was Alicia, lied in her case, because what came up in this portion of the testimony was Detective Ramos saying that they did not go to the club door. And then we looked at the club camera footage, and we did not see Alicia or Isaiah go up to the club door. So Alicia had said that they approached a bouncer and were turned away, and they were not allowed to go into the clubs, right? In this case, we looked at both club surveillance footage, and we saw that Isaiah or Alicia never approached it. So Isaiah and this interrogation said that, no, I actually did go to a club. I don't remember what the name of it was, but it was colorful. So, on cross, that came up again, that he was really trying to be adamant that there was like a third club or cast doubt or whatever. But we don't have them on the footage. I mean, it is what it is. They're not in the footage. So I don't think that the jury's going to buy that, to be honest. They talked a little bit about the bully down sign that was found in his house, the spaces conversation. Isaiah's attorney had the nerve to say that spaces conversation was cordial between Foolio and Isaiah, and it obviously was not. And you have to look at the antagonizer in that as well. Now, the cool thing about this section of the testimony that they did not do well, in my opinion, in Alicia's case, was that they had a timeline. This was actually really good, and I hope the jury was paying attention because I certainly wrote it down. It has 1, 2, 3, 4, 5, 6, 7 timestamps. 2:16 a.m., we followed Foolio's movements, right? So we have him outside of one of the clubs. Then they corresponded it with 2:17 a.m. 1 minute later, Alicia and Isaiah are on the scene outside. So I loved that they showed that footage in this timeline because there's no way that they weren't hunting, right? 2:20 a.m., you show Foolio walking up those stairs, right? 2:22 a.m., you see Isaiah and Alicia walking back to the car. So that is the moment where they spotted him and they knew where he was, right? So I thought that timeline was really important for the jury to see. 2:31 a.m., you have Isaiah and Alicia leaving. And then I can't read my handwriting here. I think 2:44 a.m., Charles leaves. Okay, so he's getting everybody together and they're all leaving. 2:47 a.m., a few minutes later, the Impala pulls into that club parking lot. So I thought that was really cool that they put that together for the jury, because now you have the exact timeline of Charles just going about his life, living his day, living his birthday. And then you start to see when these other people are arriving on the scene, and there's no way that you guys were not conspiring and watching him. You know what I mean? Like, it shows that hunting aspect. So I thought that was really important that they did there. They also talked about some of these posts. So after the shooting, I think 4 a.m. is when it happened, but around 5 a.m. there's these laughing and crying emoji posts that are going up on Instagram, and then the whole Bill Belichick thing, all of that stuff. And I wrote down that the jury should be curious about that timeline as well, especially after seeing the surveillance footage. Now, next up, Detective Ramos walks us through who he believes each shooter is. They kind of talked about this in an Alicia's case, but because Alicia was not one of the shooters, they didn't go into detail. But this time they identified, or at least Ramos, mentioned who he thinks is who and why, right? So we have shooter 1, shooter 2, shooter 3. Shooter 1 is in all black, right? He believes that's Rashad because of the left-handedness and then the way that Rashad was dressed. I mean, the boots. And I'm convinced it's Rashad. It's the way Rashad moves and the way he walks. You can even see his movement, his body language, and the way he walks in that Walmart footage compared to how he was walking and moving and running in that surveillance footage from the Tesla, right? So you have that. Shooter 2, he called the rifleman. That person was in a blue hoodie and light-skinned, and it looks like Sean. It looks like Sean. So he identified him as shooter 2. Shooter 3, we believe to be Davion, orange ski mask, husky, heavy set. The only discrepancy was in Ramos's testimony. I don't think he mentioned whether that shooter was left-handed or right-handed. It came up in Davion's closing argument, but I don't know if the jury was paying attention to that portion of it. The other thing that came up is the bags. We looked at surveillance footage from Sean's house and all of these bags that were in and out for a one-day trip, a bunch of bags. Why were the bags so heavy? Right? If it was a romantic getaway, whatever the case may be. So we did have a little bit of dialogue that day in regards to that one. The partial digital download came up again. That Tampa Airbnb came up, and we heard from Ramos on how he contacted the owner of that Airbnb. Once he contacted the owner from the Airbnb, he was able to get the ring footage and the lock information. Then he got in touch with the Uber driver. And also we learned that with this Airbnb, that's how we got the link to the other guys. So although the Airbnb was booked under Rashad's name, it was Isaiah's credit card that was used. And then later in the trial, we learned that not only was it Isaiah's credit card that was used, somebody else from ATK or 1200 sent him the money. I think it was it Spin a Benz? No, it was J. Breezy. J. Breezy sent him $390 for that Airbnb. So that transaction, we just saw it elongate the conspiracy. At first, we thought it was just Rashad and Isaiah, but little did we know it was J. Breezy, it was Isaiah, and then you link it back to Rashad. So do you see how all of that links together? It's a chain gang. So talked a little bit about that on cross. They tried to poke a lot of holes in the story. And this was, oh my God, this was a long day. This was Gonzalez. Okay. Gonzalez tried to cast doubt, tried to say that Armani Turner was not cooperative. And, I will say that Ramos did his thing in this trial. He was not bothered by these defense attorneys at all. And he's like, no, I wouldn't say that Armani Turner was uncooperative. It's just she didn't have a lot of knowledge regarding a lot of this stuff. So I wouldn't call her uncooperative. So he was not flinching when it came to that stuff. They talked a little bit about Kenny Capps, and they were like, oh, well, how come Kenny Cap didn't say anything at the beginning, or how come he wasn't involved? If he really wanted to help, how come he didn't give you a statement right away? And then, he's just like, listen, at some point we were able to interview him and he was cooperative. So what are you talking about? So, it was just Rashad's attorney had a little bit of a hard time here. They talked a little bit about Taifa as well, Aaliyah Albritton, how they hid that car. But again, Aaliyah was on probation, so that was kind of explained away. He casted some doubt on the clothing of shooter 1, the shared phone, if there was an infotainment system in the Chevy Cruze. I mean, that really didn't help. Who the car belonged to. The joint phone extraction. He said this is silly. The driver's license, Rashad's driver's license was uploaded to the Airbnb because the Airbnb owner was like, hello, Rashad. Thank you so much for booking your Airbnb. We're going to need, the condo association needs a copy of your driver's license. It was uploaded 15 minutes later. Why was Gonzalez trying to say that Rashad was not the one that uploaded it, that somebody else was using his phone and logged into his account? It was just all types of shenanigans. It was like, man, that's not true. And then he also mentioned, okay, where did he come from when the Uber got there? And we were all screaming at the TV like he was there. He was already there, Gonzalez. Why are you trying to make it seem like he wasn't there? So that was not a fun day. Yeah, and then he just tried to cast a little bit of doubt with those locks and how, Rashad was in the house or either not in the house. And then he showed proof of incarceration on 626. I mean, I really don't think that did anything. Sean Gathright's attorney did cross next on Ramos. Again, he tried to really focus on his mom being a retired Marine, talking about the ARs, trying to cast doubt on these guns. He talked about Sean being a photographer and having a pressure washing business at, what was he, like 18, 19 at this age? Apparently he has 2 businesses at this age. And when he was wiping down the car, there was, I guess, a white rag, and he asked Detective Ramos if they tested that white rag. But see, anything that would have been collected from that white rag would have been destroyed by cleaning solution anyway. So whatever. He also asked if any prints or DNA was found on these shell casings that were, recovered from the scene, and if anything matched. The traffic stop in Jacksonville was huge. They had to talk about that. There were live and spent shell casings found in the car. I think he was trying to go for like a plain view issue from when Sean was arrested. Did the officers have the right to search the vehicle? And even though they did, they found a mountain of information in there. Like there was, magazines, the 300 blackout, I think, was in there. The shell casings from the first attempt on Foolio's life 8 months before was in there. All types of stuff was in there. We also learned that Sean's sister dated Gathright. That came out. So, I think they were really just trying to show how close they were. But man, they found so much in Sean's car: 45 auto rounds, 357 rounds, rifle rounds, shotguns, magazines, the 2 9mm shell casings. He kept trying to say, like, what was found in the victim's body does not match what was found on the scene. And then we later learned in the autopsy that it actually did match. So that didn't work. The bags and camera equipment out and in, who's driving the Impala. You can't put Sean in the front seat, all of that stuff. You can't prove that he is shooter number 2. And then he talked about that landscape light making Sean look, it could have been anybody. And it's just like, just sit down, just sit down. Same thing. We had a lot with Isaiah Chance's attorneys, and I'm not going to repeat myself, but it's some of the same stuff. That colorful club, the bouncer. What he did say when it came to the colorful club is that there is another club around the corner called the Players Club, right? Did you get footage from that club? And again, I don't think it matters, because that timeline is going to shut down all of this doubt shit that they're trying to do. You know what I mean? Like that timeline where they showed Foolio and then they showed them, showed Foolio, showed them. That timeline was so powerful of evidence. I really hope the jury paid attention like I did, because that was a good tool to tell this story. Yeah, there's just more of the same with Gathright, and teasers and them being on camera. Alicia sharing her location with Sean, Chance using her phone that night, and was his phone available? A bunch of like just not convincing stuff there. Same thing, Davion's attorney came back up and he asked about the McDonald's, also tried to cast doubt on how Davion got into the Airbnb, like who opened the door for him, that sort of thing. Same thing came up, Tesla footage, McDonald's ring, Davion being on the run, and any DNA being tied to him, which there was not. On redirect, this was good. This was good. And remember, we're still on witness number 19, Ramos. So they talked about Alicia's phone being inside of the Airbnb. We learned that this is where we learned that that Chrysler that was traveling down from Jacksonville was registered to Spin-a-Benz. And then we learned who Spin-a-Benz is, and he's in the Who I Smoke song. Darius Beals comes up, and we also learn more about Darius Beals and how he was killed a few days later. Okay, so the state also brought that up. All right, we move on to witness number 20, Detective Drayback. It looks like they have been in deliberation for about 2 hours. I'm just going through my notes for anybody that is new here and just joining. Detective Drayback, we get the Twitter Spaces conversation from Detective Drayback. We listened to it. Mizzle came up. They talked about Mizzle knowing people on both sides. We got a search warrant for Isaiah's house in his room. That's where they found the gun next to the crib in his room. We now also learned from Drayback about the Walmart footage of Rashad. And then the second arrest of Rashad in July. So that's where he wouldn't come outside for 7 hours. So they talked about that. There was so Mizzle came up. I think Mizzle is on Foolio's side, and then there was another person named Fizzle. Okay, so there was a Mizzle and a Fizzle. So we had that happening. Okay. This, I think, is the day we saw Davion's interrogation footage too. And that is when Davion was talking to himself. And that's where we have the famous saying that Sean was green, Sean's green ass, right? But also in that same thing, he denies knowing Sean. He said that he was down in Tampa to meet Fizzle. And he lied in that interrogation for like 2 hours. And then eventually they played him and he started singing. Talked about Robert Howard being affiliated with Six Block, the 1200 gang signs. Talked about Crash Dummies for a bit and how Sean was an acquaintance, but he really didn't know him. Got some cross-examination for this. Rashad came up first, of course. 55 minutes for Gonzalez. It just takes so long. 55 minutes. He talked about social media being a source. And if there was a burner account, Tom Brady post, hate me kindly, renting the Airbnb, joint phone search warrant. The arrest took 7 hours, fried balls, gun to the temple. He dislocated his shoulder. Okay, and then we get to Rashad's interrogation where he's wearing the big blue blankie. And he admits that he allowed people to use his things and provided things. So he allowed people to use his phone and to use that silver Chevy car. Like, that was bad. I'm going to skip through that. Davion's attorneys came up. And they talked about the day that Davion was arrested and how he was arrested. Finally found he was at the front door. It was breached, but he was injured at that breach as well. And that's what led to the interrogation footage with Detective Nieder and Detective Drayback. His rights were read to him. He signed the form consenting. He said that he was impaired and drunk during that interview, that he appeared to be jovial, dancing and singing. And they played the music. And, you know, he tried to say that he was listening to NBA Youngboy, and we found out that that wasn't true. It was like some pop song by a female singer. There's that. Okay, I think that's all we have for Davion. Sean Gathright's attorney came up. They did admit that they were unaware of Sean's social media presence. He was not in the Uber. We got that. Davion was cooperative but not forthcoming. And anybody could have been the light-skinned fella. It didn't need to be Sean. Isaiah came up, started asking about the Spaces chat, the bigger fish to fry. He mistakenly brought up King Von's name for another rapper. Tilly was brought up as well. And the I love my girlfriend hat that Isaiah was wearing, I guess that came up in this conversation too. Redirect was pretty long on this one. Actually, no, it wasn't. This was really just focusing on Darius Beals and how that was an unrelated matter, different selfies that were taken to prove that Rashad Murphy, or one of them said that they were using the phone, Darius's phone, but it came up yesterday in closing arguments that that wasn't true because that phone was with Darius and there were 30 unlocks and they were all from facial unlocks, right? So you know how you have Face ID on your phone, that's where it came from. Okay. And okay, that was day 5. Then on day 5, that was the day I had to run out early. We missed witness number 21, which was Miss Kaufman from forensics, and witness 22, which was another police officer. Okay, day 6 started to get real. We're getting close. We had 35 witnesses altogether. This is witness number 23. Officer Legg is the one that talked to Taifa about the gun. That's what I had written down. Then we went to witness 24. Forensics, so this was a little bit long, but this forensic person really focused on Xavier Edwards, Gino Norris. They processed the Nissan Altima for all the shell casings, and then Taifa, his DNA was swabbed, and we did not get any matches there. So that was pretty quick. Davion, Father Time, came up and asked about gunshot residue and if any of these people, if their hands were tested for GSR, but we know that although they had guns, like they obviously were not firing any guns. And then he tried to cast doubt, asking why Camilla, in verifying that Camilla wasn't tested for GSR. I don't know why they think she would have a gun, but okay. Witness 25, another Tampa police officer. He had a traffic stop. I forget what that traffic stop was for, if it was in Tampa. Oh, yeah, this was a traffic stop when some of the other victims were fleeing the scene and they needed to get some help. They flagged down the officers to get some help. So I think that was the Tampa police officer. Next, witness 26, Tampa crime scene. So they processed all the cars and we talked about those. And then the search warrant was issued to impound the Charger and process the Charger. Swab for DNA, same thing with the Altima. Witness 27, Detective Griffin, that came up. This was really centered on Sean's arrest, Isaiah's search warrant, and Alicia's arrest as well. We talked about Sean's traffic stop, what was found in the back seat, the phone that was found in Sean's front seat, and Sean writing down all these phone numbers, including Rashad Murphy's and Isaiah Chance's. So we had that. Witness 28, Miss Summer D's, same thing. These are some of the folks that process these cars once they are impounded. So they went through the Gold 4Runner. She also helped participate in some of the things that were recovered from Sean's house. This is where we learned about the safe and the grip tape being tested for DNA. And we found out that Sean had a direct DNA match to that grip tape. So we have that. Witness 29, Detective Wilson, also brought up, he talked more about Foolio's, or the attempt on Charles Jones' life the first time. And this was in October of 2023, and 16 shell casings were picked up from the ground. That's important. Why? Because once we get to the autopsy, we can find some shell casing or jacketing. I forget which one it was, but I do know that I think some of these like materials were still in Foolio's foot, so they were able to match it. So that ended up happening later. Moving along, coming to witness 30, we have Detective Johnson. Detective Johnson processed the Gold Forerunner. They found more things in the center console. And then they were looking at the comparison of some of these bullets and guns, the ammo boxes, live rounds, and spent shell casings from the Gold Forerunner the day that Sean was arrested, and comparing them to what was found at his house. Witness 31, Dr. Noah Riley. This one was really hard. That, you know, for anybody that does know Foolio, I mean, this one was hard to listen to, but this was the doctor that performed the autopsy. You're just kind of talking about the cause and manner of death. And I think what that did for the jury is it also kind of walked through how he was trying to get to the back seat and shield himself, and how much of a surprise that this was when it happened. You know, out of respect, they did not show any of those pictures to the public, but they just kind of talked about like what some of those shots looked like, and some of the damage to his body. So, you know, getting shot to the point where, like, you know, it went to major organs like the kidneys, the lungs, the heart. He lost a lot of blood. It was really hard to listen to, but a majority of this came from the right side of his body, which kind of implicates that if Sean was shooter two, that it was very likely that Sean did this. Okay, so that was really, you know, that was a hard day. It was sad to walk through that testimony, but they did find some other projectiles in the body bag, things of the like. It was just so much damage, you know, his arm, his hand, like his palm, like he was really trying to get to the back seat, but you can almost kind of like put yourself in his position. And they just kind of talked about, like, you know, when he would have lost consciousness and how it would have happened so quickly that within seconds, especially with the hard shot like that, he would have been gone very quickly. So, you know, that was difficult testimony, to say the very least. I don't enjoy talking about that stuff when it comes to these cases, but long live Six, you know, like nobody deserves to go out like that. So they talked about that with that witness. Next up, witness 32. This was Detective Sheedig, I believe. This detective kind of, I think this was really looking at Sean's residence and how far it was from the stop. So they talked about Miss Lyle, Sean's mom, and how the vehicle was stopped nearby. We went through the security cameras. We talked about the clothing and these bags that were moved back and forth. So we went back to Sean's house for some reason with this person, but they looked at like door handle footage. So that's when they focused more on Isaiah's car, that BMW that was parked on the side, what was taken out of there, when they were dropped off by the Uber. And then you see Isaiah kind of walking along with Alicia as well. Then we get to Davion's interview again. He was all over the place. He went from, I wasn't there, to saying that he's crazy, to saying that people set him up, to saying that Sean was dumb and that he was a crash dummy, and all types of things. Like, that was a long day, but it was all over the place. That's when we also learned of the final schedule for this trial. So I have how they were kind of laying out this week. Witness 33, Robert Howard. This was a big day. Robert Howard was, you know, I think one of the big things about his testimony is he's just like, I'm not ratting, but I'm here to participate, right? He had ChatGPT on direct. They talked about Bibby, so Adrian Gaynor, just kind of going through the past, the difference between Cuckoo Gang and the 187 Boys, how he knows Gino Norris. The conversations with Isaiah Chance was new. Royale Smith, so 23, talking a little bit about the history with that. How Isaiah and he were like, they would have conversations, but we also learned that he was talking to the Murphys as well. The other thing that they tried to get out is determine if Fat Boy was Xavier Edwards, if that's who they were connecting it back to. Like they were trying to get who Fat Boy was. I don't think that that was very clear. He also just kind of talked about the people that were there that night. So same thing with Taifa, like how do you know Taifa? I think that was it really on direct. Now on cross, they really tried to get Kenny Cap, especially Mr. Gonzalez. He talked a lot about is Xavier Edwards Fat Boy. So again, like that came out. The communications with Rashad, what did they talk about? Did you know Rashad? How long have you known Rashad? Who reached out to Rashad first? Was it you or him? He also got him to say that he took the fall for somebody else. So like, that's why Kenny Cap was in jail. He also said that Rashad saw him at one of these locations. And if he really didn't like you, he could have shot you. Right. And it's like, oh, okay. Then we learned about the meth, the manslaughter, the battery of a police officer, exactly what he is in jail for. Okay. So, you know, he brought that up in his closing argument, but this is less about Kenny Cap and more about what your client did, you know? So interesting stuff. But yeah, Robert Howard takes the fall for Bibby. Darius Beals killed 6 days later. That was really it. Witness 35. Crime scene analyst comes back. We had a lot going on there. And then we went back to Detective Ramos. We learned about the Cash App from J. Breezy. Rashad also searching on Instagram in the middle of the morning, even though he allegedly was not there. The Airbnb records, an address shared with Sean screen recording. We were talking about that. We did watch the Do It video. Spinabins came up again. The debate between the pants and the boots. Explaining the hunting. The Players Club came up again. And oh my God, all these attorneys are really trying to cast doubt, but it's like he's not at the front door like he said that he was. I'm talking about Isaiah. And same thing with Alicia. She said the same thing. They also did a little brief timeline here where at 2:27, there was a phone call where Isaiah and Alicia are outside, 2:27 a.m. But the image that was captured showed at 2:31 a.m. That's when he was holding the phone. So Isaiah's attorney was trying to show that there was a small time discrepancy. I don't think that the jury paid attention to that. They also talked about Sean being a creative player. We looked at the escape footage. He ripped his ankle monitor off. Witness 36. 6-year-old rap song. Yeah, witness number 36 was a Jacksonville detective, I believe, and they were talking about the 1200 unit, going through the history with Jacksonville. Is it a gang? What it classifies being a gang? Who was classified as being a gang member? That sort of thing. Gang experts came up. Oh, this is the day I had to leave. This was that lady that came up. Oh my God, do y'all remember that gang expert? That was like the defense's only witness. And she was like flown in from LA or somewhere and didn't really know what she was talking about. That was their only witness. Then we went to closings, and I went through closings yesterday, so I'm not going to do it again. But that is your case in a nutshell. Lots of stuff here. And yeah, that is where we are. That's all 35, 36 witnesses. Lots of evidence, but I have been polling you guys for days to see who you thought was the most cooked. And I do believe we ended up with starting off with like 30% Sean, you know, and then when we ended getting close to the end of this trial, we ended up with 65% Sean being the most cooked out of all of them, or at least having evidence that ties them to this crime. Going to do a refresh. Jury is still in deliberation as of 10:25 a.m. I'm going to read some super chats and then take a break. But here's the game plan. And this is what I do with every trial that we cover on the channel. Usually I'll do what I just did there, walk through the entire case And now that you, court of public opinion, have the same evidence that the jury has, this is what they're talking about. They're likely doing what I just did, walking through their notes and their notebook, walking through every single piece of evidence, walking through every single witness, talking through everything to see if they can convict these boys for the crimes, right? First degree murder, okay? So that's what's happening there. Let me read these super chats, and then for the rest of the day, my editor has made a thumbnail for verdicts time. What happens is we'll break for the day, right? So after I read these super chats, we're going to be on standby. So what I'm going to do is immediately create another live stream. I'm just going to schedule it for 10 o'clock. But basically what happens is as soon as the verdict drops, I hit the go live button. So what I need you guys to do is once that live is scheduled, put your go to it, put your notifications on and set an alarm. So what it's going to do is the minute I go live, it's going to be like, hey, AV's here, the verdict's in. So I just want to make that clear. I'm going to see if I can automate that for you guys, but that's how you do it. Okay. So just make sure that you set it. And I will also put if you follow me on Instagram, I will put a post up immediately when the verdict is out. So y'all know to come back here and we can watch it together. Because at this point, it's they're 2 hours in. We're going to go into the afternoon. It's almost lunchtime for them. So we can get a afternoon verdict. But remember, like that just took me an hour to go through everything. So it might take them maybe 2 hours to go through all of that stuff too. So I think we're going to get a late afternoon or an evening verdict. Tomorrow's a bit of a stretch. I think that nobody wants to stay overnight. So we might get an evening verdict. Reminder, Alicia's came out at 10 p.m. Okay, so that's why I'm just going to set the stream for 10 o'clock. But if it comes earlier, we can just set it up and go right away. Shout out to the Real Swoosh, who became a new member. Welcome. Welcome to the Chatterhood. We're a good bunch here. Love watching trials and, love watching with accuracy. So that's always a great time. Love it over here. Shout out to Carrie. Carrie's been around forever, but she became a member as well. Shout out to Malik with the 5 says, I think the verdict will be this afternoon. The jury is done and want to go home to their families. Just saying. Yeah, I mean, like I said, there's so much evidence here on these boys that they conspired and they worked together to get this done, and the hunting aspect alone, if I'm thinking about it, the 2 most powerful pieces of evidence that they used, one, I think was that timeline. That was very smart of Detective Ramos to put that together to show what Foolio was doing, what they were doing, what Foolio was doing, what they were doing. That's huge. That was perfect. I mean, like now that I'm looking at that, that was amazing. The Sean thing where Sean's going through his phone and trying to find that address, he's done with that. Super done with that. You can't unsee that. I think those are 2 very powerful pieces of evidence. Shout out to Christopher Williams. No comment, no question, pure love of the game. Dropped a $100 super chat. I appreciate you, brother. He's been with me forever. Been through so many trials on this channel, watching with me. I appreciate that. Shout out to Tess, who became a new member. Welcome, Tess. Gonna love it here. Valeria gifted 5 memberships. I did write this down. The Publicist got 1. Beelin got 1. Shanita got 1. Miss Lady Grady got 1. And Southern Girl got 1. Speaking of Southern Girl, and thank you, Valeria, for gifting those memberships. If you got one from Valeria, please say thank you to her. Southern Girl dropped a 10, says, AV, you're the GOAT. Great channel, great chat. Long live 6. Happy Mother's Day to Mama Foolio and all the mothers in the chat, me included. And I agree with those sentiments. Happy Mother's Day to all the moms there. If Foolio's mom is watching, happy Mother's Day to you. This is very, very tough, but I hope and I pray that she gets guilties today before Mother's Day. I think that would be great because at the end of the day, she wants justice for her son. She lost a son, and then look at what's happening with all this. These other mothers are about to lose their 4 sons, so interesting stuff. But thank you so much, Southern Girl. Shout out to Lovely Lady with the 2 says, okay, it's in the hands of the jury now. Yes, the jury is deliberating. They have been since 10:25 a.m. You guys are still split. I have 2,000 votes. I asked how long for the verdict. 40% of you say this afternoon. 40% of you say this evening. 11% of you say tomorrow morning. And 9% of you say tomorrow afternoon. So it's in the hands of the jury, chat. Shout out to D with the 5 says, I believe these young men are about to learn that actions have consequences. Yeah, and some of them are looking at the death penalty. You think Judge Sisko she's not going to play with them. They can come up for hours on hours on hours during the penalty phase next week. And, they're going to ask for mercy. But in the state of Florida, the death penalty is on the table, right? Death by lethal injection. These are very serious things. But at the same time, it was serious for you to take somebody else's life, but also look at how you're endangering the community by shooting into a fully booked hotel. 3 other people, and I talked to you guys about those headshots. Gino could have died. Xavier could have died. Camilla could have died. Any of those girls that were there could have died. This could have been far worse. So, the state of Florida is not playing with what these boys did. And that's why the death penalty was put on the table. All those families that were inside of that hotel, it could have been me or you in that hotel room sleeping. Imagine if you just sleeping and then bullets start just flying into your room. It's crazy. So they're being very hard on these boys, but this is not a game, Shout out to D with another 2 says everybody gangsta until they go to court. Yeah, and then there's a little bit of tension between the Murphy cousins. We saw that yesterday afternoon. So, you have a lot of broken ties here. Lots of broken ties, all for something that's just really silly, But thank you so much, D. Shout out to Antoine, been with me for 3 months, says they're going to have the verdict by the end of lunch. Antoine's like, they're going to be done. Like, we just went through it. We just went through all 35 witnesses. Yeah, they still got to talk. Because in some of these closing arguments, like even Sean's attorney is just like, that's not the same gun. So they have all that evidence back there in those rooms. They have the guns in those plastic bags. They have the ballistics, everything that we saw, all those little envelopes. If they want to open that up and look at those pieces of evidence, they can. So it takes a little bit of time. That's why I'm guessing late afternoon or early evening. But thank you, Antoine. Shout out to Nomenclature with the 2 says, AV, is it 8-12 for DP in Florida? Huh? 8-12 for DP? Oh, 8-12 for the death penalty in Florida. Is that what you're saying? I don't understand the question, Noman. I'm sorry, Noman. I don't understand that. When we were talking about those verdict slips, the judge kind of outlined, and although we can't see them, the verdict slip basically is like a checklist, and the jury has to select what options there are. So we talked about murder in the 1st degree, right? She explained murder in the 2nd degree. She talked about manslaughter. She talked about justifiable homicide and excusable homicide if it was an accident. I don't think any of those are going to apply. You're probably going to land somewhere in the murder in the 1st degree, I think for all of them, really, because it can't be 2nd degree, because that's like if you have a depraved mind, and then it's definitely not going to be manslaughter. I think it's going to be murder in the 1st for all of them, to be honest. And she went through the elements of each of those crimes, right? Like the person is dead, the information it was caused by the defendant. There was premeditation and deliberation. You had the intent to kill, all of those things. She walked through all of that stuff. But then that's the first thing you see on the verdict sheet. Each one of them has a verdict sheet like that. But then you have all of the counts. So the 2nd count might be, okay, Xavier Edwards, here's what you did to him. Gino Norris is another count. Camilla Bentley is another count. All of those counts are on there. So the jury has to go through 4 separate verdict sheets and then look at the criminal culpability for each one of them. Now, when it comes to the time, that's something that the judge is she's the one that's going to determine that, not the jury. The jury is just looking at if they are guilty of these crimes. That's the penalty phase. So for those of you that are watching, and Law and Crime did announce it, they're going to televise the penalty phase next week. Okay. So that's going to be from Monday afternoon. I think she said Monday from noon all the way to Thursday. So each one of these 4 defendants, they're going to be able to call their witness list and ask for mercy for their time, right? She did also talk a little bit about aggravated battery, the principal theory to a crime. Like, remember, they were trying to say that Isaiah was the main principal to this crime. And then you have gang enhancements too. So if you think about everything I just explained to you, you have that for each of them. Okay. So they have to fill out these forms for each of them when it comes to those things. Most of y'all are just like, listen, check, 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 done. Let's go home. Like y'all are ready to check off everything, but it does take a little bit of time, right? So that's why we're just kind of waiting. And she did talk a little bit about some of the rules, right? They have to consider every single witness. So what I just did with you guys, go through all of that. They have to consider all pieces of evidence. So that means opening up them envelopes, looking at these guns, looking at what was found, all of that stuff, right? Looking at the digital forensics, looking at all those reports. It's going to take a bit of time. The defendant's statements, the things that they had mentioned. Sometimes they're going to have to review video. So they'll review video from these interrogation pieces of footage and stuff like that. All right. This is like a full force, ordeal. It's an operation. It's like a little war room, so the jury has to go through all of that stuff. And they're going to question each other. If one person believes something that another person doesn't, sometimes they will have these debates. What was that movie, 12 Angry Men? Sometimes you'll have people that are convinced of one thing, but people that are not convinced of the other. And then they have to agree because the decision has to be unanimous. So it comes with a lot of debate. Right? So you're going to see that. Now, the jury is allowed to come back out. And this is why law and crime leaves it open like this, because sometimes a jury will have questions. If they have questions, they can send a note. They'll probably take a little, Post-it, give it to a bailiff. Hey, bailiff, we have a question for the judge. They'll bring this note. They'll run it over to Judge Cisco. Judge Cisco, bring everybody back into the room and say, all right, guys, the jury has a question. The jury will all have to come back in, file in, and then the foreperson will ask their question. Okay, so sometimes if they're having trouble with understanding how the law works or how it applies, they can come back and ask those questions. So hopefully that helps, but sorry, Noman, I just went on a tangent there. Shout out to Michael Love with the 5 says, I agree. Once they showed the timeline of the victims and the hunters, the cell phone info, the dinner bell rang. Yeah, that's it. And that was so early on, so I'm happy we just went through my notes because that timeline was perfect. They didn't do that in Alicia's trial because I think it's because she wasn't a shooter, but it did show the hunt. I think they could have done that effectively in her trial. But doing that was a great visual for the jury. Like, here's what Foolio was doing. Here's what they were doing. Here's what Foolio was doing. Here's what they were doing. And it also shows the unawareness of, he was just living his life. You know what I mean? He was just living his life on his birthday. There was no cares in the world. You know what I mean? So they can't use anything that has to do with self-defense or try to blame any of this on him at all, because obviously you can see that footage of him just being a person, living his life, doing the show. It's not even a drinker. That was huge. We learned a lot about who he is as a person, but it also showed that he was not really fazed by this stuff. He wasn't bothering these kids, so it's interesting. But thank you so much, Michael Love. Shout out to Hollywood, who gifted a membership. Thank you so much, Hollywood. I appreciate it. And if you got that membership from Hollywood, please say thank you if you received it. He does it all the time. Appreciate you, brother. Shout out to Shanta with the 5 says, in Florida, it's LWOP, and successful appeals is like 1%. They have the death sentence either way. Yeah. Like Alicia Andrews got very lucky with this appeal. Very, very lucky with this appeal. And for those that were looking for an update on it, she has a court date on Monday. I just checked her case file. Let me check it right now. I don't think they moved it yet. But as of right now, I think that is still on the books for Monday. Let me check. It was at Monday at 8:30. I checked like 2 hours ago. So let me check again. Alicia Andrews, here's her case. I don't think they moved it yet. And Miss Doherty, Michelle asked yesterday for a continuance on that, because if we're going to be in this court, we're still going to be in the courthouse handling this other stuff. Let's go to hearings. Page 2. Yeah, they haven't moved it yet. It's still showing us May 11th at 8:30 a.m. They were talking about possibly doing it on Zoom, but it does say in person. So 8:30 on Monday, it says motion pending case status review. So they're going to review Alicia's case 8:30 and decide whether she's going to get a new trial or not. So a lot is riding on today and tomorrow. Depending on how these boys are found, I mean, there's no way that Judge Fernandez, because it's a different judge, is not going to look at weighing all these options without the impact that it could have on her case. Like, is she going to get a new trial? Because really all that appeal did is remove Judge Sisko, this judge, from her sentencing. 'Cause that was the last thing, is Alicia just needed to be sentenced. And then this appeal happened and the judge was removed. So now Jeremy and team are pleading to have a new trial, and that judge needs to make a decision on Monday. It's a heavy next few days, but let's see what happens, you know? Thank you, Shanta. Shout out to Miss Butterfly. No comment, no question, just pure love of the game. Thank you so much, Miss Butterfly. Really appreciate the $20 super chat. Rhonda sent me a $5 super sticker. Thank you, Rhonda. Really appreciate you, sis. Coming over to Imaginary Asshole with the 5. Thank you so much. Says, AV, do you smell a RICO case? Let's talk about RICO. ATK gang, Young and Ace, Spinabins. Do you think they were accomplice and ordered the hit? Strong case. All right, let's talk about RICO. So the RICO laws in the state, or not even just the United States, were really designed in the 1920s, 1930s, 1940s, way back in the day to combat organized crime. It's really kind of targeted for, like, you know, mobs and things of the like Italian mafias, different type of organized crime like that. It's a very old, construction of the law, right? But what it does is it's designed to take down a criminal enterprise. Now, with RICO, you don't really see it used lately, though. I would say in the last 3 to 4 years, it's been used heavily. So a big example of that really started coming out of Georgia, where we saw the YSL case, and you also had President Trump's RICO case, okay? So, you know, Fulton County, we talk about that place a lot on this channel, but that's really where I started to get very familiar with the way that RICO can be used. Now, in YSL, they tried to say, they indicted 31 people at first, and tried to say that Young Thug, AKA King Slime, was the leader of this criminal enterprise. And really, that was a gang war between I believe Bloods and YSL in Atlanta, right? And oh my gosh, I can't believe this was 2 years ago at this point. But that case took so long to try because you went from all of these people on that original indictment list, and each of those people either had to select whether they were going to take a plea deal and do the time, but there were like something like 64 counts. Everybody had a different count, but they didn't all have the same ones. So it was this big indictment, 60, you know, like 31 people, but 60 crimes. But like, let's say you're defendant number 4. Defendant 4, you might just have count 1 and count 50, right? Then we can go to defendant 5. Defendant 5 might have count 7, 8, 9, 10, and y'all know Lil Woody had like all of them. So, you know, sometimes there are people that have way more crimes, but it's really designed to take down the enterprise at once. Now, on the contrary, President Trump, with the election interference case, was also part of a Georgia RICO. They try to say that he tried to steal the 2020 election, was making phone calls and doing all this stuff. So they indicted him. And I believe that one was 16 people in total, but only like 4 or 5 wanted to take it to trial, right? Including President Trump. So all of those defendants had to fight that RICO case, but they were trying to say that the president was a part of an organized crime, you know, or an organization, a criminal organization to, you know, further a conspiracy of racketeering or whatever the case may be. In that case, it was an election. Now, compare it to this. Diddy, they tried to say that Diddy was doing a RICO, right? And that RICO was involving sex crimes. So it can be transformed in so many different ways, but really what it has to do is with an organization. So with Diddy, was that bad boy to bring all these people from different places in order to, you know, for him to have his what were those freak off parties? You know, like what was, you know, this organization being used for, right? And so there's all types of ways that RICO could be applied. Now, sometimes it does involve federal things. So if you have people that are in different states, it's hard to describe, but sometimes if you are committing crimes in different states, you have like some interstate stuff going on as well. Now, it could happen, possibly, but I think you would need way more on Young and Ace, right? And instead of just the music here, you're going to need a lot, like tying it back to a leader of a gang. So if you look at the Trump thing, the leader of that was Trump. If you look at the YSL thing, the leader of that was Young Thug. If you look at this thing, they're going to have to put it on a leader. And who would that be? Would it be Young and Ace? Who is the leader of ATK, right? Like they would have to really, really tie all of this together, but also show how it was a conspiracy, how they all conspired. Is it possible? Anything is possible, but it would have to, it's going to be a big investigation. That's what these things are. And that's why, you know, in Georgia, Fonnie Willis does get a lot of heat because, you know, these are very ambitious type of cases to bring forward. And the reason why is because you need a lot of resources, a lot of attorneys, a lot of investigators to do this work and research. And if you're really trying to take down a criminal organization, you're gonna have to work very closely with law enforcement to get it done. Now, here's what happens. In Georgia, that YSL RICO fell apart. It wasn't successful. In Georgia, that President Trump RICO fell apart. It wasn't successful. So it's always risky when a prosecutor has to make a choice if they're going to use and devise RICO and use it as a tool to take down a criminal organization. You can't miss. You have to be very sharp if you're going to use that as a legal mechanism to take down a criminal organization. So I hope that kind of helps explain RICO a bit. But, you know, if they were to do this with ATK, Young and Ace and Spin and Benz, it's going to be a Herculean effort, but like, you know, whoever decides to do it. So if it starts in Tampa or in Jacksonville, you know, the investigative body and the prosecuting body has to be tight if they're going to take that on. Your next question, do you think they were an accomplice or ordered the hit? Strong case. If they were accomplices. Now, I think with Young and Ace, it's conjecture. I think it is theory. I think that they would need something very sticky to pin it on him. As far as ordering the hit, Spin a Benz is, I mean, that you have that Cash App transaction, it's $390. So you obviously see that he's involved somehow, some way. You see the black Chrysler traveling down there. He's obviously involved somehow, some way, but I think more evidence needs to come up. You know, that's stickier to say that they're absolutely involved and absolutely ordered the hit. I think with those two things, it's hard to say, but it definitely shows involvement for sure. But if you gave me those two things and you wanted me to go argue the case, that's weak. You know, I mean, it implicates, yeah, but that's weak. We would need more. So I think if it is in development, and you have some really strong evidence and sticky evidence that could absolutely help. What do you guys think? Do you guys think that there is a RICO brewing based off of that conversation that we just had? You guys think that ATK can be looking at a RICO? Is it a criminal organization? What do y'all think? Let me see what Keyshawn says. Keyshawn says, based on this case, I don't think they have much on Ace, maybe Breezy. J. Breezy, sorry, Slim. When I'm reading what y'all say, sometimes, you know, there's a lot going on here. So Cash App transaction is J. Breezy, and Spin a Benz, you have the car. But look, that made it even weaker because you just have one thing on each person. Okay, we say no here. Forks and Facts says no. 2X says, I think it was 1,200. It's possible. Okay. Someone's got to fold. They don't have enough. You guys are saying they don't have enough. The government will definitely go for it. RICO equals the money. Nope, not a federal RICO. Look at that. I'm educating y'all on the law. This is great. Let me see. I think I got one Cash App that came through. Shout out to the Neptunes fan. He's been here throughout the entire trial. He sent me a $50 Cash App. Thank you so much. I really appreciate that, brother. Okay. All right, guys. Well, listen, we are on verdict watch for the rest of the day. I am going to knock the stream down for a second. I'm going to set up the new stream that is going to be designed for the verdict as soon as it comes in. When it comes in, here's what we're going to expect. When the verdict comes in from the jury, we are going to have the foreperson come in. They are going to have all 4 forms. The judge is going to say, jury, have you reached a decision? They are going to say yes, and then they're going to read what they came to for each one of the 4 defendants. Once we get there, they'll likely talk about the next steps, if they're going to be, put into custody. They're already in custody, but like where they're going to be going, and then what next week's penalty phase is going to look like. So Judge Sisko's pretty tight with that. I would ballpark it for about an hour stream. Right now, I'm going to earmark this for 10 o'clock. But like I said, make sure that you put the alarm bell on. So as soon as we go live, we go, so that's really what we're going to be looking at. Let me see what you guys think. 2,600 votes. I'm going to end the poll right now. Thank you guys for voting. I asked you how long for the verdict. 40% of you say this afternoon. 40%, you guys are still deadlocked. 40% of you say this evening. 11% say tomorrow morning, and 11% say tomorrow afternoon. I'm going to go ahead and end that poll. And I will see you guys later on this afternoon. I need to get ready for a Fox News interview, but talking about this case, but I definitely wanted to give you guys some context, give you what the evidence was like, what they could be debating on back there, what evidence is strong, what evidence is not, the performance of these attorneys, and go from there. So it's going to be a pretty interesting day. I'm looking forward to it. And, really want to thank you guys for watching, hanging out with me. I know you can watch this trial anywhere. I know you can get the information anywhere, but I really appreciate that you took your time out of your day to watch with me. So I will see you guys in a few hours. Stay safe out there. See you in the next one. Bye.